20. The petitioner. There may be some difficulty. I pay for on 31st.
31st or 1st of April? Whatever. 1st of April. Much of it.
Consent of DRS still unconsolidated. Repeat from age of listing. 114. First of April.
Much of it.
Deeply obliged.
May I please, Your Lordship? I beg to mention item number 23. I, on behalf of FKR Ahmed.
20.
The matter,
Just a second. 20.
the matter may be taken on Monday.
20.
23. Item number 23. 23.
Receipt. You have some difficulty.
Monday. I, on behalf of
Just say,
FKR.
listen, Monday, if you're able to, then only we'll give you Monday. Monday, lots many of matters. As per you, it will be on Monday.
Monday or Tuesday?
We'll see to it. Monday or Tuesday. 27th of this month.
20.
27th. Aji no korbe Monday.
May I please your May I, Your Lordship?
Yes,
Lordship, I beg to mention item number 29, my lord.
29.
29, my lord. CD was called for that has not been received probably, my lord.
Yes, what is the position of 29? Are you on interim?
Yes, my lord. I am.
City not received. Issue reminder. Yes, Botaku, when it can be.
7th of April.
7/4, interim be continued till next year.
Deeply obliged.
Item number 22. I have filed an additional affidavit. I most humbly pray for the requisition and to tag it to the.
Additional affidavit you have filed already.
Yes, sir.
Okay, we'll call for it.
May I please, Your Lordship? I beg to mention one CRP for listing.
Make a mention before court number 8.
Sure.
That is your lordship. Lordship, you'll find the FIR at page 13.
Page 13.
Page 13. A long FIR, lordship.
Hmm.
And the vernacular is at page 15.
Hmm.
I, Akash Mandal, aged about 27 years, father, late sons of village, yes, Kukrajar, district Kukrajar, Assam, hereby submit this complaint with utmost humility regarding the brutal mob lynching, illegal detention, and subsequent death of my elder brother, Anand Mandal. I beg to state that on 26/1/2026, my brother Anand Mandal went missing from village, and a missing report was filed at police station on 27/1/2026. Later, we came to know that he was falsely accused of cattle theft by some local resident in the Talapara, Badgaon area, which falls under the jurisdiction of Kokrajar police station and was mob lynched. Based on the false, baseless, and unproved suspicion, some people gathered
So as in, it is a case of mob lynching.
mob lynching, lordship.
The person died.
I am 76 years old, lordship. I have not even touched him, lordship, because I am physically weak, lordship. And now I am behind the bar for 41 days, lordship.
Yes, Botaku, when it can be.
Yes, my lord. On 27.
27. CTV call for it.
Obliged.
May I please, Your Lordship?
Yes.
Regular bail application, my lord, FIR at page number 9. Allegation is that, my lord, on 7/2/2026, at night, my lord, one car has been parked in front of the house of the informant, and when she inquired about the car, he come to know that some person got out from the car, covered with their face with clothes, my lord, and he made him cry, and thereafter the car was fled away by the unknown person. They were fled away. Then he informed to the police station about the incident. Then thereafter the police, my lord, arrested the said recovered the said vehicle and arrested one Amir Hamza and some iron rod, hammer, dao, etc. has been recovered from the car, my lord. That is the and also that Amir Hamza informed that there are some other person, namely Sekandar Ali, Rajkumar and Shahadar Ali. They were subsequently arrested. But thereafter, after 20 days, my lord, I was arrested on the basis of the statement of the Amir Hamza. This is the allegation. Now I am 18 days behind the bar.
Okay. Yes, board.
Not only, my lord, state on the grounds of arrest, my lord, reflects that not only statement of the Amir and the other independent witnesses also against the present is also there, and the present accused person is habitual offender. Earlier also, my lord, he was arrested in connection with Boko PS case 246 oblique.
But that is filed by my wife against me. That is filed by my wife against me, my lord.
But my lord, regarding that aspect, whether that case was filed by the wife or not, that is not only the case number.
He is in 18 days behind the bar
18
when
days.
it can be called.
Nothing has been recovered, and in the forwarding report, my lord,
Allegation is of preparation to commit dacoity.
Dacoity, yes, that's right.
ground number
Call for
2,
against there, he also
everything
maintains
has
they
been.
call for.
Need short on 27th,
27.
or before that also, 26 or 27,
26.
26.
All right.
26.
The FIR at page 9, Your Lordship,
Page 9.
vernacular at page 11, Your Lordship. On the basis of this FIR, Your Lordship, I was arrested, Your Lordship. This is a false allegation brought against me, Your Lordship, and an incident of 18 to 26, about 12 days back, has been referred to here, Your Lordship. And the person died on 1st of March, Your Lordship. And while he was working in a number, he collapsed in the floor, and thereafter he was rushed to the hospital. And there he was taken to the hospital in the morning, and in the afternoon, late afternoon, he died. But then the incident of 18 to 12, 26, Your Lordship, which has been referred, that was a minor scuffle, Your Lordship. The accused was apprehending a thief, Your Lordship, and he was manhandling the thief. And at that moment, the person who died, he came and he interfered. In the process, he was hit by the accused, Your Lordship. He fell down, and he was taken to the hospital. There was a minor injury on the head, and there was nothing. And he was he was visiting the Namghar every day, Your Lordship, after 18th, because of the religious functions, Your Lordship. And on 1st of March only, in the morning, while he was working in the Namghar, performing religious duties, he fell down on the floor, and therefore he was taken to the hospital. So the cause of death cannot be related to the incidence of 18th, Your Lordship, after 12 days. There was only minor injury, and that he was not hospitalized also. Only by dressing the injury, slight injury, he was allowed to go home.
At this stage, though, it cannot be said, but maybe there's internal hemorrhage was there, I think.
Yes.
It caused subsequent
But
death.
then the report from the hospital, Your Lordship, Jharkhand Medical was, that will clarify everything, Your Lordship, that the cause of death was not the head injury, Your Lordship.
So you have
He died
we have
of a
already
card-
seen.
In fact, he died of a cardiac arrest. That was the information gathered from the hospital, Your Lordship.
Okay. Yes, what?
Regarding that instruction, my lord, whether he died due to cardiac arrest.
That is the informal information, Your Lordship. That is not formal. Your Lordship.
But now from the FIR reflects that, my lord, while this old person, my lord, interfered, my lord, while he was arguing with, then at that point of time, because of the, my lord, he assaulted And thereafter, after 12 days. only.
He's saying that maybe out of that incident, he may get injury because sometimes it happens,
Happens.
blood doesn't come out.
Yes,
They-
yes.
These things that happen, na?
Only PM
And if
report.
any internal injuries are there, sir, hemorrhage may be there or
Yeah,
clot may
yes.
be there at this point of time, we cannot say. That may be the reason, or as he have submitted that maybe another reason also, I don't know.
Only PM report will reveal.
PM report will reveal and things will reveal. But prima facie it is in that as per the FIR, I'm not
Yes,
saying
yes.
otherwise, as per the FIR out of that assault made by you and one
But-
other, the
The
incident.
person, deceased person was working in the Namghar for 12 days regularly. He was visiting the Namghar regularly, Your Lordship. There was nothing, no complication. Lordship. Only on,
Cannot say now, but the allegation is brought against you.
this is there, Your
Yeah, I
Lordship.
don't know.
But the allegation
Since
is not,
1-3 they are in custody
because-
since when?
because to fulfill the graph that there was a couple and the old person was hit by a young person of,
Phil Grass, how, where he will be saying?
that is why
Minors couple
this
was there
application,
only.
this complaint was
So
made,
he
Your
got
Lordship.
arrested when?
On 1st
On 1st of March,
2nd of March.
2nd March. Okay, then yes, what happened?
On 23rd or 20.
Alia, Your Lordship.
Earlier, we don't have any date.
Earlier on,
From when, where it has to come?
from Jura.
Earlier,
When-
next Monday, Tuesday, Wednesday, we don't আহিব জানো? Because 19 yesterday, we have fixed many matters on 19. At least 20 can be given. 20 then?
Tuesday.
Lordship may consider giving an interim, Your Lordship. Because I'm a young person of 23 years, Lordship. I'm the only son. I have to take care of my parents here also.
No interim, 20 March.
Interim till 20.
No interim. That are Microfinance.
Wait, please, Your Lordship.
Yes.
Lord, allegation of murder is there. Lordship may kindly call for the trial court record. He's behind the bar since, Lord, 10 months ago, 11/5/2025, he was arrested.
Since then, it is a charge sheeted case.
Charge sheeted case. Trial is going on.
Okay.
Lordship may call for the trial
As
court.
per you, how many witnesses, is there any evidence recorded till now?
Lord, that is the problem. Evidence of none of the witness has been recorded yet. Lordship may kindly call for the trial court record. Fix it after 2 weeks.
Scan copy of the TCR along with the CTP call for. Raised will lead to needful. After 2 weeks, anything. 31st of March.
I'm aware.
Maybe the lordship.
Yes.
So of course, this is second bail application lordship. Now it is filed by only father-in-law. Lordship that case lordship.
It's the second bail application.
Yes, lordship. Now as on today lordship 76 days stand behind the bar lordship. It was filed earlier lordship. That's why first one has rejected that some investigation may be required. Now perhaps it may be completed lordship. Now 76 days lordship. And whole family were behind the bar lordship. That's why I am filed this for only for father-in-law lordship. And there is no allegation, especially allegation in the FIR lordship against him lordship.
Oh, that is the case where
Yes,
the,
Yes. Yeah.
Yes, lordship.
very
Dying-
tactfully it is stated that one dying declaration was there.
Yes, lordship.
But in fact, that my lord, from the earlier rejection order, my lord, probably at the instance of the accused persons, that dying declaration was maybe my lord, may not.
Yes, yes, it seems
was
to.
recorded. Yes.
The dying declaration was recorded in the absence of the other family members. And it seems that in the instance of, you rightly said,
Yeah.
for the accused person, that has been recorded.
Yes.
It seems.
Yeah.
Now, your petitioners is behind the bar, how many days?
76 days now.
Yes, on that contract, if you want to say something.
Yes. On
Only at least this person will consider lordship. Otherwise, lordship, only two minor child is in the house lordship. They are any guardianless lordship. Mother-in-law is there is also lordship behind the bar. All other behind the bar lordship. Only two children is there lordship. Yes, sir. At least if father can go there, they can maintain at least that two children lordship.
Habibul Islam, who is he?
He's
He
the
is the
father-in-law.
husband,
Father-in-law lordship. He's father-in-law.
Huh?
Habibul is father-in-law lordship.
father-in-law.
Yes, lordship.
Yes, what according to submit. In earlier occasion, you applied for bail for how, 3.
Husband, father-in-law, and mother-in-law, Lordship.
Now you are applying only for
On
father-in-law.
father-in-law, yes, Lordship.
Why? Others rest are already on bail.
They are Lordship, they said that they may not allow, they may not get bail, Lordship, there, so they will come later, Lordship.
They may not get bail.
That's all, Lordship. They are not saying that first they try for the father-in-law.
Oh, let
Yes,
us
Lordship.
try for father-in-law.
On 24th of March 23 or 24.
Lordship, kindly attend to 20, Lordship. 24, Lordship, another case is hearing at the State Consumer Forum, Lordship. Kindly make it a 20, Lordship. 20.
Okay.
20.
Check.
Oh, Lordship.
CDB call for bail.
May it please your lordship. Lordship, this is a regular bail application. FIR lordship will find on page 7.
This is the main accused person, Baharul Islam in Bihpuria, my lord.
Oh, that Baharul lordship. What happened in this case, lordship? Baharul was picked up by that
Okay, but
civil
calling
dress
for the
police.
case died.
Yes, lordship. That.
Well, it can be.
My lord, on 31/3, my lord.
30.
Highly obliged.
May I please your lordship? Lordship. 483 application lordship. Petitioner was arrested on 22 lordship. He has been shown arrest lordship. And today is lordship 21 days. Allegation under section lordship 304235 lordship. Chain snatching lordship.
Chain snatching.
Yes, lordship.
It is 304 now.
3042 lordship.
So familiar with all these sections. Snatching, chain snatching. Yes, but
My lord, on 1st of April.
No, lordship, before it, lordship, any
many
day,
matters.
lordship.
How it will be accommodated before it? Many matters are there on it.
On 30.
Another case is lordship fixed on main cases. He has been shown arrest in this case, lordship. Item 7 and 8 in both the cases he has been shown arrest. And the main
Item
case
7?
fixed on 9 lordship.
What item 7 and 8?
19 lordship.
Hey,
Main case that's shown arrest is it?
এটা কি ছোট না
এটা খুনফিল
এগুলো একটা আমার উল্টা কাস্টমার টু 20 দিন দুটা both 7 and 8
7 and 8
out of this is and 2 FIR.
lordship.
Yes.
2 FIR.
Two
Out of, yes. lordship.
habitual offender, my lord, chain snatcher.
Yes,
Their name is, his name is not in the FIR, lordship, but only on suspicion he was arrested.
How his name will be there?
Yes, my
He's
lord.
the same I mean snatcher.
Yes.
How his name will be?
Yeah.
20 we cannot give. Not many matters have already
On
been fixed.
33, my lord, 30 or 31.
30.
30.
30 can be. This time let him celebrate it inside the jail. What to do? There are many matters. 33.
Oh, bless you.
Otherwise, also in jail authority arranges a good. You can have a bhalo.
633.
7 and 8.
May it please your lordship.
Yes.
But in this case, my lord, the FIR, my lord, is at page number 11. Allegation is of chain snatching, my lord. Probably out of coincidence, but it may be related to the previous items, my lord, but I do not know. But against the present petitioner, my lord, the only allegation, my lord, is that he had received some of those properties, my lord, which were allegedly snatched, my lord. Now, if your lordship will kindly see the section under which the FIR has been registered, it is only registered under 3042, only snails snatching part, my lord. Against me, my lord, there is no allegation of snail snatching, my lord.
Where is the forwarding?
Forwarding, my lord, is at page number 19.
Hmm.
He is the owner of a jewelry shop, my lord, he is a jeweler.
They are all associated with little one compromise. Yes, he is a jewelry shop
He
owner.
is a jewelry shop owner, my lord. And police, my lord, without any verification, my lord, seized all the items, my lord, all the jewelry and cash, everything, my lord, connected or unconnected to this offense, my lord. But the FIR, my lord, was registered under only 3042. Prima facie, my lord, there is no allegation against him, my lord, with regard to snake snatching, my lord. It may be a case of, my lord, receiving of stolen goods, my lord, but that section is not there in the FIR.
When he got arrested?
Yes, the 17 to 26 days.
Is it out of same FIR or
Yes, my lord.
out of same FIR?
No, my lord. Those cases are Jaluk Bhai. Student cases, student. Here also Raju Ali is involved.
Oh,
The accused person who is involved in the 7 and 8, my lord.
acha, acha.
That Raju Ali is also, my lord, probably
Oh,
involved
that
in this case.
Raju Ali.
After snatching the same, my lord, probably he sold all these items to the present petitioner, my lord. And regarding adding of that section, my lord, I will have to get the instruction, my lord. Probably that section added, my lord, may not be in the, yes.
But the certificate copy
We'll have
obtained
to
on
get the
9/3.
No, is there any prayer from IO that we are not in a position to say anything in that regard? Initially, definitely,
Yes, yes,
the section was registered under 3042.
yes.
But after recovery,
But my lord, before my lord arresting him, that section should have been added, my lord, because forwarding does not reveal that section, my lord. He was arrested on the previous section only, the snatching part.
yes,
He could not have been arrested under this section, my lord.
he got arrested. Now,
Yes.
yes,
Some
Port
case-
Harcourt when it can be.
Yes, sir.
He is also, he is not Raju Ali, he is
No, my
Moinal.
lord, he is
Moinal Haq.
Moinal Haq, my lord.
Moinal.
Your lordship may kindly come to page 22, ground number 4, my lord.
4. There,
4 and 5.
on such stolen gold and silver ornaments along with cash amount were recovered and seized from the possession of accused
Otherwise,
Moinal
only
Haq by
because these accused persons are involved in receiving those stolen articles, and because of that, my lord, these accused persons.
But those case numbers
So
are not
the-
referred here, my lord, in this forwarding, my lord. In this forward, my lord, this case is related only to that one thing, my lord, that was allegedly snatched. Even if, my lord, we admit, my lord, that probably would have been recovered, my lord, by now from his shop, my lord. Because it says that possession of stolen gold and silver ornaments, my lord.
because present against present accused may not be other cases are pending. So, my lord, your lordship, at this stage, CD may be called for, my lord. From CD, everything will be, my lord.
It is fixed on 19 that.
Yes. Otherwise, my lord, only on technicalities, my lord, if this
Technical
persons
ground is there, obviously there.
after
because-
perusing this CD, my lord, if there is that section was not inserted, I has not filed any application, I will get the instruction regarding that.
Well, even on merit, my lord, if I submit, even on merit, my lord, 26 days, my lord, everything has been seized, my lord, from his jewelry shop, connected or unconnected, my lord. So probably, my lord, for investigation purpose also, my lord, sufficient time he has been in jail, my lord. But my lord, if CD lordship wants to see, my lord, no problem, my lord. But the thing is that, my lord, before it, if any date.
19-3, my lord.
It didn't. It did not. It will be on 18th.
18, my lord.
18.
Hello.
With your lordship.
Yes.
So, regular bail application, my lord. Petitioner was arrested on 3rd March, my lord. The FIR is on page number 11, my lord.
Yes.
I would like to report that I am an unemployed educated adult searching for government job under Government Railway Department recruitment circle for job vacancies was open. About 15 days ago, accused Motiur Rahman so and so, stating that he had good relationship with some railway officers and they could help me and others to get the job in Government Railway Department. Today, on 2nd March at about 12 p.m., as told by Motiur Rahman, I, along with my father and so came to so hotel. Then Motiur Rahman introduced the other two accused persons, so as officers of Government Railway Department. Both of them also introduced themselves as electrical engineer of Government Railway Department. Then all the accused person took PAN card, Aadhaar card, educational qualification certificate, etc. documents of me and so. They asked us to keep ready rupees 2 lakhs in cash for each to get the railway job. This conversion was not satisfactory and we asked them to show identity card. Then accused so one identity card but did not allow to take photo. Later we brought them to Paltan Bazar PS and came to know that they are not railway officers. They have shown false ID and all the accused persons have conspiracy longer. That's the allegation, my lord. I am Motiur Rahman. I have nothing relation with the two co-accused, my lord.
That you are the person who introduced the other co-accused person. As
Yes,
per the FIR.
I have no knowledge regarding the false ID card and all, my lord.
Oh,
they were
All-
caught red-handed while dealing with the complainant and other taking money and some
but
identity.
you are the person who managed to get a job in
Yes,
the railway
yes.
department, introduced to two other co-accused persons who are not the government employee. So everything against you only.
Forwarding is at page number 14, my lord.
Yes, page number 14. Against you, there are many items in one number 4 also. That you have earlier also conducted the money from so and so.
Yeah, at this stage, a CD may be called for.
Obviously, it has to come from which place now?
Kamrup Metro.
Paltan Bazar, no?
Paltan Bazar.
Why it is Borpeta, not Borpeta?
Paltan.
Officer in charge of Paltan Bazar police station. Yes, what Thakur, when it can be called.
My lord, on 27th,
27.
Yes.
Very good. And no one replied. None appears on call for the petition. Let the matter be accordingly listed. After 1 week, as on a date to be explained.
May I please your lordship? My lord, 482 application, my lord. FIR at page 11, my lord. As per the allegation of the FIR, my lord, that the victim is the husband of petitioner number 1, my lord. He is committed suicide, my lord. The allegation is that on 25/1/2026, my lord, the petitioner number 1 and his family came to his house equipped with dao and lathi and physically tortured him, the deceased, my lord. And thereafter, my lord, a FIR was lost from the both sides, my lord. And that FIR was compromised by the police in the police station. Thereafter, my lord, after 13 days, my lord, it is alleged that from that day, the petitioners used to threaten to the alleged victim, and in fear of life, he committed suicide at his own residence, my lord. The case is registered, my lord, under section 351 subclause 3, 109 subclause 1, 108 and 117 subclause 2, my lord. 151 subclause 3, it is a criminal intimidation, my lord. It is a bailable section. And 117 subclause 2, it is voluntarily causing grievous hurt. It is also bailable, my lord. My lord, section 109 subclause 1, it is attempt to murder, my lord. So attempt to murder, this section does not attract here because is as per allegation, my lord, some quarrel was there and the FIR was lost and that FIR was compromised, my lord. And after 13 days, he was committed suicide. Now section 108 is there, abatement of suicide, my lord. Now whether there is any abatement in this case, my lord. In the FIR, it is clearly says, my lord, he committed suicide on his own residence, my lord. And he is a husband, my lord. Usually there is a quarrel between the husband and wife, my lord. And on 25/1/2026, there was a quarrel between the husband and wife. And in that day, the family members, that means the petitioners, my lord, came to her matrimonial home and take her away. In the FIR, it says that on 25/1/2026, the petitioner number 1 with her minor son left the house of the husband and take shelter in his parents' home. After 13 days, my lord, he committed suicide. My lord, at this stage, my lord, CD may be called for, my lord, and till then we may be given some protection. We will cooperate with the investigation.
I objected regarding the interim lordship because in the FIR itself, it is stated that in the last few lines that the accused persons above named used to threaten my brother to kill in life, in fear of life. Lordship, my brother Nurul Islam committed suicide. So in these cases, Lordship, the nexus has to be there, and that only can be ascertained by going through the CD, Lord.
It is a family dispute, my lord. Quarrel between husband and wife.
But it can only be ascertained after looking into the CD, Lord.
There were the cases between the parties, compromise was also there. And subsequently, she left the house with her minor child, the wife. And thereafter she left her matrimonial house. When she left her matrimonial house on the same very day, acha. That means on 25/01, she left her matrimonial house.
Lordship.
And he committed suicide on last night, that is. Obviously, after 10-13 days, he committed suicide.
I humbly pray because, Lordship, if these statements are not there, Lordship, in the FIR, I won't have said, Lordship. But it is clearly stated, Lordship, threatening part is there. So it may lead to, Lordship. I will take not much time, Lordship. Shorter day time may be fixed.
My lord, it's not good to say, my lord, that the Eid is there in front. The baby child is with outsiders, my lord, because the father is committed suicide. Mother is behind the bar. Grandparents and one mama is, he is also maternal uncle. He is also behind.
This is AB, isn't it?
Who
is behind?
Oh, sorry, I'm sorry. They are escaping, my lord. They are escaping, so the baby is
During most probably during no one will be arrested, right?
Short day रहता है, short day रहता है.
Otherwise, if it is see that I can also see that she left her matrimonial
my lord,
house
on
along with his
25
child
on
because
after 13 days, he committed suicide. And
but the last line he mainly the
my
last
lord,
line,
in actually
that
what
if-
happened, my lord,
suppose from telephonic information also, if someone threatened that will kill you some days on so and so, that you
Only
fight
that
with
line
committee.
for that line.
actually what happened, my lord,
I don't know whether it will amount to an abetment or not. Let us see.
That is a different note.
my lord, actually what happened, my lord, the husband is a habitual drunkard, my lord. He usually come to the home and there is a quarrel between the wife, my lord.
Maybe.
And he borrowed many money from many persons. And the pressure was also upon him. So in many causes, he committed suicide.
Maybe.
So
Maybe it's
allegation is, my lord, protection may be given, my lord.
That's why we are giving short.
19.
19 of
19.
my lord, obliged.
18.
Obliged. May I please?
Yes.
Anticipatory bail application, my lord. FIR is at page number 18. This is the vernacular one, my lord. May I read, my lord?
Yes.
বিনীত নিবেদন এই যে মই জাহিদ হুছেইন শ্বেখ মই হাতীগাঁৱৰ LNB পদ বাইলেন 3ত ভাড়া থাকোঁ মই পুৰণা গাড়ী কিনা বেচা কৰোঁ আৰু অনলাইন ট্ৰেডিং USDT কাম কৰোঁ যোৱাকালি 15/2/2026 তাৰিখে গধূলি 5 মান বজাত আজিজুল নামৰ গোৱালপাৰা ল'ৰা এজনে মোক ফোন কৰি তালেব নামৰ ল'ৰা এজন 6 মাইলৰ ফখৰুদ্দিন আলী আহমেদ পথত থকা হোমষ্টে এখনৰ লগ কৰিব কয় আৰু তাত 4-5 জন ল'ৰাই USDT ট্ৰেডিং শিকিব সেইমতে মই উক্ত হোমষ্টেত গৈ পোৱাত তাত মোক বহিবলৈ দিয়ে ৰাহুল নামৰ ল'ৰা এজনৰ লগত আৰু 4 জন ল'ৰা আহি মোক ৰুমৰ ভিতৰত মোৰ মোবাইল ফোনটো কাঢ়ি লয় আৰু মোক 5 জনে লগ লাগি মাৰপিট কৰে আৰু মোৰ পৰা মোবাইলৰ পাছৱৰ্ড লৈ মোৰ ট্ৰেডিং একাউণ্টত থকা 4659 USDT মোৰ লৈ বেলেগ এটা একাউণ্টত ট্ৰান্সফাৰ কৰি লয় আৰু মোৰ লগত থকা নগদ 1,75,000 টকা তেওঁলোকে কাঢ়ি লয় তাৰপিছত মাৰধৰ কৰি লৈ তাৰ পৰা মোক বাহিৰত লৈ আহি মাৰাৰ ভাবুকি দি থানাৰ ওচৰলৈ লৈ আহি থানাত সোমোৱাই ফাৰ্ষ্ট ফ্ল'ৰত এনে আন কাৰোবাৰ লগত কথা পাতি কাকো একো ক'ব মানা কৰি থানাৰ বাহিৰত লৈ গৈ এৰি দিয়ে এটা মোৰ মোবাইল লৈ যা এটা মোক ঘূৰাই দিয়ে লৈ This is the FIR, my lord. I am not the FIR named accused, but the FIR named accused Rahul is my elder brother, my lord. And the homestay is belong to the Rahul. Initially, police started to searching Rahul when they failed to capture Rahul, my lord. They started to searching me. I am a student of BA, my lord. So at this stage, my lord, I am apprehending arrest because they could not arrest Rahul, my lord. They are now behind me. Only CDP call for my lord and interim protection may be given because I am a student, my lord, BA student, my lord. Rahul is my elder brother, my lord. His name is there in the FIR. And the homestay is run by Rahul, my lord. Is his homestay, my lord. And that apart, my lord, one Taleb Ali who was named in the FIR as the accused, he was granted bail by the Learned Session Court, my lord. I have the order, my lord, recently granted bail, my lord.
Where Taleb Ali's name is there?
Yes, my lord. Taleb. In the second paragraph, ল'ৰা এজনে ফোন কৰি তালেব নামৰ ল'ৰা এজন 6 মাইলৰ ফখৰুদ্দিন আলী and his original name is Abu Taleb, my lord, and he get bail, my lord. I got the copy downloaded from my lord.
Yes, Sharma.
My lord, here, Lordship may call for CD, my lord, to find out his involvement, my lord. Here, allegation is on robbery, my lord.
Yes, my lord.
And rupees 1,35,000.
Yes, my lord. That's correct.
But why they took him in the police station?
My lord.
As per the FIR,
My lord.
মোক মাৰধৰ কৰি থানাৰ ওচৰলৈ লৈ আহি থানাত সোমায় why they and whatever had done they in front of police station only?
My lord, থানা my lord. তেওঁলোকে কাঢ়ি লয় তাৰ পাছত মাৰধৰ কৰি তাৰ পৰা মোক বাহিৰত লৈ আহি মৰাৰ ভাবুকি দি থানাৰ ওচৰলৈ লৈ আহি থানাত সোমাই ফাৰ্ষ্ট ফ্ল'ৰত এনে কাৰোবাৰ লগত কথা পাতি
কাকো একো ক'ব মনা কৰি থানাৰ বাহিৰত লৈ গৈ এৰি দিয়ে That is, my lord, regarding the Rahul, my lord, I am younger brother of Rahul, my lord.
এটা মোৰ মোবাইল লৈ যায় এটা my lord, CD may call for my lord, for that my lord, I will produce the case there, my lord.
I am a student, my lord.
To find out his involvement, my lord, whether he is also may also involve, my lord.
There is only an apprehension, my learned friend is, my lord, but so far the allegation is the FIR, my lord, is against my elder brother, my lord. And I am therefore I am a student.
I am done in common. So hard. Mr. B. Sharma, the learned petition BP, bring on the opposite. It's an application. It is submitted by Mr. Hussain that the present accused petitioner is innocent and he is no way connected in the alleged offense. police is searching for him only because he is the elder brother of one of the accused, Rahul, who used to run one homestay. But the present petitioner is no way involved in the alleged offense. However, he is ready and willing to extend his cooperation in further investigation of this case if he is granted with some interim protection. Mr. Sharma, the learned additional PP submitted in this regard that though the name of the present petitioner is not mentioned in the FIR, but only CD will reveal his involvement in the alleged offense. Accordingly, he insisted to call for it. Considering this submission made by Land and interim protection. Okay, you'll be granted with interim protection.
Highly obliged.
Yes, both of them will.
My lord, CD, my lord, on the 6th of April, my lord.
Highly.
There will be some direction
Mine.
applied by all the directions.
May I please, your lords? There is an anticipatory bail application in this. FIR is at page 13.
Yes.
Your lordship will find, your lords. May I read, your lords?
Hmm.
I beg to state that I am the president of Rajdhani Mandal of Bharatiya Janata Yuva Morcha, Gauhati. I am submitting the instant FIR to bring to your kind attention the following events that happened with me. At around 12:45 AM today, on 12/1/2026, I was returning late home as I was engaged in preparation as regards the occasion of festivities of Yuva Divas to be held at Srimanta Shankara Palaka grounds. While I was driving my vehicle, being Maruti Baleno, while beating registration number so and so, I was stopped by a mob. Around 20 to 12, around 25 people at 6 Mile Daranta near Karmosri Hitasashaika College at around 12:47. Upon stopping my vehicle, I was immediately dragged out of my car by the leader of the mob, who then started to scream, abuse me, and incited his goons and minions to beat me up, requested them with folded hands to let me go, but the mob started to break and damage my vehicle and mercilessly assaulted me and beat me with hockey sticks, rods, sticks, etc. Looked my face, neck, stomach, chest with intention to kill them, and I saw brandishing daggers and other sharp objects with intent to use them to kill me, and one of them even brandished a pistol and pointed it towards me. I was repeatedly struck on the chest and stomach with hockey sticks and dragged on the road through rough ground to further injure and possibly kill me. The aforementioned group of miscreants dispersed when I somehow managed to escape from their classes for a moment and call my seniors and colleagues who were still in Srimanta Shankara Palakhetra working for setting up the festivities of preparation of work. On the occasion of Yuva Divas, my senior and colleagues reached my location shortly and called the police. I was taken to Dispur police station where my brief statement was recorded, and thereafter I was rushed to GMCS for treatment. My previous injuries. I have attached copies of the reports and other medical documents as well as USB drive containing a video showing my grave and previous injuries along with my FIR for your ready records and perusal. Even though there were several people in the mob, I managed to recognize some of them and they had roaming around in the area 3 months the whole day, and me and my colleague were working as aforesaid. The details of the persons I recognize are as follows. Your lordship will find that my name is not there. And your lordship will kindly see the name Nirupam Pathak, the person who was brandishing and pointing a pistol at me. He was driving. He was granted interim protection by the learned session court, your lordship. Absolute bail, your lordship. I believe that the aforementioned individuals are residents of Juripa locality of Gauhati. Now, your lordship, on the strength of this, your lordship, the FIR has been lost. Before going to my case, your lordship, I just wanted to point out, your lordship, your lordship will kindly come to page 17. One of the connected accused, your lordship, who was not named, he was granted bail by this honorable court by order dated 27/1/2026, which is presently pending, your lordship. Your lordship was pleased to fix it on 27 to
2016,
2020.
26.
27 to
Yeah, 26.
26 3 2026. Since medical report was not there. This is by your lordship. Now your lordship may kindly come to para 6 of my petition, your lordship. In fact, I was not involved. I was a bystander. I have seen this, and this is a your lordship clash between two group of youths, your lordship, belonging to two different political parties, your lordship. Group clash, and your lordship, some even from the other group who is being accused of assault, your lordship. Their vehicle, etc., has also been damaged. Those were your lordship in the police custody, your lordship. Those damaged vehicles, etc. Your lordship will kindly come to para 6, your lordship. This has happened in front of my house, your lordship. I went there, your lordship, and therefore, your lordship, now police is also having seen this in in the CCTV, your lordship, was there, your lordship, was also after me, your lordship. And your lordship, already, your lordship, the person concerned who has allegedly shown pistol has been granted absolute bail, your lordship. Therefore, your lordship may call for the case diary on 27, your lordship, to be taken up along with the other matter. In the meanwhile, your lordship may give me some protection so that I can cooperate and give my statement to the police, your lordship.
My lord, here lordship may call for CD as the matter is fixed on 26/3 at this stage.
Lord.
Administration.
26.
So as brought forth the land council the petition also had distribution in
Yes, Lord.
It's an application under section Swens in connection with Swens. Submitted by Mr. Bott for the dependent accused petitioner. He is no way connected in the alleged offense. The statement made in the FIR also, it is seen that there was a group clashes between two parties out of some political rivalry. And the present petitioner is searching by police as the entire incident had happened in front of his house. However, some of the identified persons have also mentioned in the FIR, wherein the name of the present petitioner is also not there. However, the present petitioner is ready and willing to extend his cooperation if some interim protection is provided. Next, Mr. Sharma, the learned additional PP, raised objection and submitted that city may be called for to know the actual fact of the case vis-a-vis the involvement of the present petition. Hearing this submission made by Swens. Okay, will be under interim protection.
Madam. 26/3, madam.
Oh, sorry.
Along with the others.
Deeply obliged.
May it please your lordship. Well, 482 petition, my lord, FIR is page, my lord, 12, and relevant portion is page 16, your honor. There is some, the FIR, alleged in the FIR, my lord, there is some gold ornaments is theft by some unknown person at Numulugar Township, my lord. And the present petitioner, he is a, my lord, gold shopkeeper. His shop was at Rupohi, my lord, Nogao. Now, police came to his house and searched all his house and shop, and nothing was found. And he is directed to appear before the police station. So that is why, my lord, this petitioner before your lordship, he also cooperated with the police, but in the meantime, some interim protection may be given so that he can cooperate with the police, your honor. And his name is not shown in the FIR. After getting the certified copy, lordship, he came to know there is some incidents happen in Numuligar police station, and one Izadul Haq was arrested, who is hailed from his town, lordship. An entire 3 or 4 gold shopkeepers were searched by the police, nothing was found. And one of this is petitioner also. So,
Yes,
My lord, here lordship may kindly page 16, my lord, FIR, my lord.
yes.
Second para, my lord. On the night of so and so, and early morning so and so, some unknown miscreants committed theft at 13 different houses within the NRL township premises. These incidents have caused substantial loss of property and created a sense of insecurity among the residents. Cash and valuable jewelers of approximately 50 lakhs were reportedly stolen.
So my lord, main accused was arrested. So I am the shopkeeper, Your Honor, and my kindly see my lord, paragraph 11 of my petition. I am categorically stated that the police came to my house and shops. Nothing was found after searching me.
At this stage, Lordship may call for CD, my lord.
But yes,
Somehow he may also involve in this case also, my lord.
my lord,
If
how
someone
can
enters
I,
full
my lord?
my lord, as
I am
he is the
my-
jewelry shop, my lord.
My shop is, my lord, at Rupohi at Nogao. The incidents take place at Numuligor. So I am the shopkeeper, the jeweler shopkeeper. So many people come to my shop. So how can I know who is the thief or who is not? That is what I want to cooperate with the police. I will disclose my identity, everything, and they have searched my shop and house. Nothing was found. One motorcycle that is taken by the police without giving any seizure list. Nothing was. So at least at this moment, my lord, ED is nearby, my lord. So that some protection if lordship is given, so I can produce.
You are
appear
Mr.
before the.
NC Das?
Yes, my lord.
Pardon, Mr. NC Das in an petition. Pardon, Mr. P. Sharma, the land edition. It's an application. It is submitted by Mr. Das for the petition. The present petitioner is in smoking. He is only. The present petitioner is a gold shop owner and he has a jewelry shop. Wherein the police visited and found nothing and did not seize anything as there was and did not found anything of the theft articles, any theft articles. However, he was called for by the police, called for in the police station, and for which there is an apprehension of arrest and present petition has been filed by him seeking the arrest. So, he is still ready and willing to extend his cooperation in the investigation of this case if an interim protection is provided. Next, Mr. Sharma, the learned people submitted the district that the being the jewelry shop owner has every probability of receiving the stolen goods, and for which the CD will reveal the actual fact of the case. Accordingly, Mr. Sharma raised objection. Considering the submission made by so and so, we granted interim. Okay, you will be granted interim protection till reciprocates time.
Yes, madam. In the meantime, I may be allowed to appear before the.
Allowed? No, you have to.
Yeah, okay, madam. Within 10 days, Your Honor, because after getting certified copy.
No, 7 days. 7 days, within 7 days, you have to.
My lord, 7th of my lord April.
April.
7th April.
There will be some other conditions abide by all the conditions.
My lord. Much obliged. May I please,
Yes.
lordship.
For item number 24 and
25, my lord, here. CD not received, my lord. IO has prayed for another date, my lord.
in 25.
24 and 25. 23rd mentioned, my
My lord, may I submit one thing, my lord? In this case, 6 or 7% has been arrested, my lord. And the main accused has been already entered on bail by the learned SDGM, my lord. On the ground that the investigation has substantially progressed, my lord. We are the, my lord, we have been arrested on suspicion ground, on the basis of the statement.
And the case there is lying on the SDGM, my lord. Sodor 2.
And my lord,
SDGM?
in
Sodor
SDGM?
2.
in 24, if my lord kindly peruse the
It is Kamur Metro.
My lord.
I mean 40 days in behind the bar 24. 40 days today. 60 days is mandatory period.
You are on 40 days and the other one 25, 40 days.
Same days, ma'am.
Same days. And notice regarding my lord, notice under section 35 was not my lord, complied.
It's just cyber PS.
Cyber, my lord.
case.
Cyber case.
Cyber. FIR my lord, as page number 10.
Jal Jeevan Mission.
The LS amount has been transferred to the account of one Moyur Jyoti, my lord. And he has been granted bail by the learned court below. Dominic. Is number 25, my lord. The bank authorities has informed the informant that the amount has been transferred to the account of one Moyur Jyoti. Page number 25.
My lord, it is a cyber crime, my lord. Several persons are involved, not only one person, my lord. They are all of them organized, my lord. From one account to one account, it was transferred, then it was transferred to the, within a minute, my lord. It was transferred, my lord, amount. In such type of offenses, my lord. Lordship may call for, my lord, CD will police on 19th, my lord. 19th.
No.
Okay, can be 19.
No, my lord, if my lord, the learned PP did not able to produce the, my lord, then in that case, my lord, I may be allowed to do this. I will approach the trial court.
You want to withdraw?
Lord.
Today. Today, CD
Today
not
itself
the-
you want
on
to withdraw?
19th. I prefer on 19th.
Therefore, my lord, I may be allowed to do this.
They like to withdraw.
You want to
today.
withdraw this? You know, you can also. Yes, same order for you. Pass 25. Hard Mr. Arani, JM. For the petition. It's submitted by Mr. Sharma that the CD not received and which is lying before the court of learned Mr. Ali Arif Ali submitted that they want to withdraw the same as by instructions. Prayer allowed. Let the both the matters be yes, disposed on withdrawal.
Dispose of on withdrawal.
Obliged.
Lordship, the matter may be passable for the time being, Your Lordship, after something.
26, my lord, here. Charge sheet submitted, my lord.
That's it submitted and you
My
want
lord.
to submit anything?
Lordship, may be
Please
taken
not
up
submit.
after some time, Your Lordship.
After some time.
Yes.
My lord, here also charge sheet submitted, my lord.
Police have become very proactive nowadays.
Why? It is submitted within the period.
That is what very proactive. I'm appreciating.
Appreciating.
They always think that we are here to criticize them.
Then what do you want to approach the learned?
My lord, that would be better to do, because your lordship may observe that the investigation is complete and charge sheet has been laid, so the petitioner is directed to approach below.
Mr. M. response, the learned counsel for the petition. Also, Mr. It is submitted by Mr. Sharma that case has already been charged. Yes, by
I charge sheet number 29 of 2026, dated 27 to
27th of
February.
February.
27 to 2026. Just 26.
Does it is in that
27.
In that context, Mr. Bispa, the learned counsel for the petitioner submitted that accused is in custody. Since when they are in custody?
My lord, they are in custody for 35, 6-2.
6-2. From 6-2.
From 6-2.
From 6-2 2026. And hence, considering the length of detention, they may be released on. As the case has already been charged, the petitioner is hereby directed to appear before the learned trial court below with an appropriate application for bail, which may be considered in accordance with the above observation, the present petition. You made your submission, one submission, we have recorded that they are behind the bar from 6-2.
My lord, I think this is the lordship's indulgence regarding item number. No.
38.
My lord, 38 also there is, I am appearing, my lord. I am told that there is the report has not come. My only, let it be fixed next week with an interim, maybe continue, my lord.
Interim was earlier there?
Yes.
38.
Report was called for whether any case is registered or pending.
We have not received that.
Not received.
Report not received. Issue reminder. The additional PP will do the needful. List accordingly when it can be.
23rd month.
23, so. It will be okay for you, 23?
23rd.
My lord, let it be 23rd, I'm there, no? 23rd, 25th, I'm going. 23rd.
Interim be continued till next.
Okay. I'm so deeply obliged.
28.
Yes, 28.
CD not received, man. They are interim, man.
You are on interim? CD not received. Issue reminder. Yes, Sharma, when it can be?
My lord, the April, my lord, first week, 6th of April.
6-4 koidibo. Interim be continued till next day.
Much.
CD receipt, man.
No, it's okay. But the informant side is also there. One Amit Goel is.
Amit Goel.
He is not here, no? Yes. Can we inform him? Can we inform him? CD you have received?
CD received, man. After some time, man.
He will try to just inform him. After some time. But I manage for Amit Goel boli ajon advocate ase. Either Amit Goel ase, one Mr. A. Chaudhary is also there. We'll try to get the numbers and we'll try to manage for some time.
31 also, man. Case they received.
31. You are on 31?
Lordship, 482 to pay the petition, your lordship. Here, we appeared, your lordship. Before the police station, I appeared, your lordship. The SP 11 is the PF FIR, your lordship. 12 is the vernacular portion, your lordship. Yeah, the allegation is that lordship accused has committed some illicit relation with the informant, your lordship. She's a widow lady, your lordship. And before that, your lordship, we have some complaint regarding against that victim or informant, your lordship. For that reason, your lordship, we also file a complaint against that informant, your lordship. That is at case number, your lordship. 16, your lordship, that is complaint. That was prior to that FIR, Your Lordship. Because of that only, Your Lordship, whole incident happened, Your Lordship. This is a false allegation against me. Yet this one is a consensual relation with the informant, Your Lordship, that is admitted, Your Lordship. I have admitted that one is a consent. I am also married man, Your Lordship. Because of this, the relation, my personal life has, Your Lordship, in danger, Your Lordship, was in danger. So I leave that relation, Your Lordship. For that reason, Your Lordship, the informant has filed this FIR, Your Lordship. And prior to that, Your Lordship, we have filed a complaint, Your Lordship, that is at 3rd of December, that is at page number 16, Your Lordship.
Against whom?
Against that lady, Your Lordship. Lady and some siblings of that lady, Your Lordship, some neighbor, saying that, Your Lordship, because they used to assault me, Your Lordship, by inviting me to their residence, Your Lordship. That is my allegation, Your Lordship, in that complaint, Your Lordship.
Yes,
My lord, that is, I do not know about that affair, my lord, but here there are allegations against the earlier also continuously this accused person, my lord, involved in harassing the my lord victim, my lord. Earlier also in such a incident, he in fact signed, my lord, in presence of other witnesses, my lord, he signed a declaration that I will not do this type of things again. This is one of the. Later on again, my lord, repeatedly he is involved in committing, my lord, the same offense. Day and night, he, my lord, that no one is.
Run through the statement of the lady.
Yes, ma'am. It is not that only one time, my lord, he has committed this offense. Earlier also, my lord, my lord, he in fact, my lord, visited. Then thereafter, my lord, because of that, my lord, the neighboring area, my lord, he in fact made a declaration that he will not do this type of offense. So it is not that,
He
my lord,
sometimes again goes, again
yes.
stay there, again come.
Yes, yes.
Her name is Deborah, the learned counsel for the petition. And also heard Mr. Pibot, the learned additional PP, appearing on behalf of state respondent. It's an application, section so and so, in connection with so and so. Is there a receipt? It's submitted by MS Bora, the present counsel for the petitioner, that day after obtaining the order of interim period bill, he appeared, cooperated in the investigation, and his statement is also recorded by the IPF. She further submitted that the accused and the victim had a relationship, and as there was disturbances in his family, he tried to tried to get rid of the present victim, but as he refused to continue the relationship, she lost the affair. However, the present petitioner is still ready and willing to extend here his further cooperation if required by police during investigation. Next, Mr. Gauhati additional PP submitted in this regard that she brought various allegations against the present petition, wherein it is alleged that he committed rape on her, and in earlier occasion also he committed same kind of offense, wherein in with the wherein the matter was earlier compromised with the intervention of the elderly people of the society. Mr. Bottom accordingly raised objection and submitted that it is not a fitness to extend the privilege of pre-arrest bail to the present petition. But hearing this submission made by the process, I have also read his record and the statement made by the victim. Considering the materials available in the case report, case diary, the cooperation extended by the present petitioner and the circumstances of this case, I find that pastoral interrogation may not be necessary. But the purpose of investigation, accordingly, the deputy is to extend the privilege of pre-arrest bail to the present petitioner in view of this experiment. The order of interim pre-arrest bail dated 08/01/2026 is hereby made absolute with same terms and conditions. Okay, you are granted absolute.
Much obliged.
Back to my lord, case diary not received. Petitioner is in interim.
CD not received.
Interim is there, Lordship.
CD not received.
CD not received. You should remind them to make continued till next day of listing. Yes, or when it
On my lord, 8th of April.
8th of April. You are 33?
Yeah, 33, my lord. As per my instruction, my lord, no case registered against the pending and registered against the pending.
But have we received this report?
Yes, my lord.
Report received.
Report, my lord. Here there are 3 petitioners, my lord. Yes, only against Abdul Salam, my lord. Well, earlier again one fresh report was called for regarding petitioner number 2 to 4. Well, after some time, my lord, I will try to obtain. Well, sorry,
Before we have received this
report is there received.
Is there injury report?
My lord, CD received, my lord. The petitioner number 2 and 3 is in interim. They appeared. In regarding my lord, injury report, my lord, I have not found any injury report in the case diary, my lord.
Injury report was called later on, my lord. PD was received on earlier date. On that day, injury report was called for.
Some statement of the witnesses is there, my lord.
Mongol 23. Mongol 23.
Ascend.
Petitioner number 2 and 3 are in the interim protection, my lord.
From the statement of witnesses, my lord, it reflects that some quarrel between the my lord, husband and wife is going on. Oh. Hello, injury report also we have received. Opinion, my lord. Simple injury, my lord. Soft tissue injury, my lord, by blunt force.
109 essential ingredients are absent. Section 109 essential
with portion injury.
Yes, injury report, my lord.
No, portion.
WhatsApp we have received the injuries. Yes, ma'am.
Head or
Receive.
no. It's where part of the body.
Yes. On tenderness of her chest, tenderness of her, my lord, left shoulder. So,
2 and 3 were on interim, na?
2 and 3 are interim. There may be quarrel between husband and wife, my lord, but not amount to 109 now. Yes, my lord.
Here,
Uh,
who is the
tenderness of
husband?
her
Number
left
1 is the
shoulder.
husband.
Yes, one is the husband, 4 is the brother-in-law.
Who is
Reside
the
in
brother-in-law?
brother-in-law in this another place. And
3 is the
3 is mother-in-law.
mother-in-law.
4 is 2 is father-in-law.
4 is father-in-law.
Sorry, 2 father-in-law, 3 mother-in-law, and 4 is brother-in-law.
And
Two,
my
three
lord, witnesses
father-in-law,
only stated that sometimes my lord, quarrel is going on
Quarrel-
between the husband and
As usual,
there is no,
course, my lord.
otherwise there is no such other materials.
When in as usual course also, can a husband beat his wife? Do you agree with this? As usual course, huh? Administrator Ilan counsel for a petition. So Mr. P. Waterford Ilan additional PP appearing on behalf of state respondents and applications students in connection with students stated received parents. Injury report is also received to the ILO. It is submitted by Mr. Halway that there is no such incident had occurred as stated in the FIR. However, it is the fact that there was a quarrel took place between the victim and the petitioner number 1, who is the husband of the victim, and that apart there is no other incident. However, after obtaining the order of interim pre-arrest bail, both the accused petitioner number 2 and 3 appeared before the IO, and cooperated in the investigation process. However, all the petitioners are ready and willing to extend their cooperation in the further investigation of this case. They are provided with the privilege of pre-arrest. Mr. Waterford Ilan additional PP submitted statement that from the statement made by the witnesses in the FIR, his diary, it seems that the quarrel took place between the husband and the wife out of some matrimonial disputes, and the victim also sustained some minor injury, that is the tenderness on her chest. Considering the submission made by learning counsel for both sides from materials available in the case diary, and also considering the injury sustained by the victim and other aspects of the case, I find it that it is a big case wherein all the petitions can be extended the privilege of pre-arrest. In view of this, the petitioner, the interim pre-arrest bail granted to the petitioner number 2 and 3, dated 12/02/2026, is hereby made absolute, and the applicant can give 1 and 2. Okay, you will be under interim, not interim protection, you're absolute.
Oblige, my lord.
If it was said, no? May appeal also.
Case diary we have received.
My lord,
In this
seriously.
case, after interim, my lord, petitioner appeared before the IO, my lord, and recorded his statement, my lord. It is the case of the 2018, my lord. FIR is case 8, my lord. A
Case
petitioner
of
not
2018.
18, my lord. And petitioner is not named in the FIR, my lord. But some of the accused person is arrested subsequently, my lord, in connection with this case, and nothing was recovered or seized, my lord.
কি recover?
গাড়ি
নাই মানে।
রিকভার হওয়া নাই, আমি তো নাই আইন
ও, আপনি তো-
Tata 207. That was stolen.
My lord.
Now, yes.
My lord. Here, my lord, one vehicle was stolen, my lord. That is number Tata RDI, my lord. Hereafter, some of the accused person arrested, my lord. From the accused person, it reveals that it was sold to the my lord, present petitioner, my lord.
Oh,
To the present petitioner, my lord, Ishaq Ali, my lord. Thereafter, at rupees 1 lakh rupees, my lord. Thereafter, my lord, he was not cooperating with the investigation for a long time, my lord. Thereafter, after interim, he has appeared. But after that interim, my lord, he has not cooperated with the investigation, my lord. He has not disclosed. The vehicle is yet to be recovered.
Yet to be.
Yet to be recovered. He has not disclosed the vehicle. Where is the vehicle?
My lord, kindly see forwarding report, page 14 of the other accused, my lord. Where from the petitioner's case, I don't know, my lord. Forwarding report, page 14 of the other two accused, my lord. Who is the main accused, my lord? Mozmul Haq, my lord.
Yes.
Involvement in dealing in the stolen property. During investigation, it is revealed that the accused person is involved in dealing with the stolen vehicle. On 23/4/18, apprehended one suspected, one lifter, Sri Ajay Chaudhary, son of so-and-so Dispur, and on the basis of his intimation, three other accused persons, namely Habibur Rahman, so Rahul Busmutari, and Jiten Das, from Patshala, Borpeta, arrested in connection with the case. During interrogation, the above four accused persons in custody, it is admitted that admitted by them that they have stolen the Tata so-and-so goods carrier, vehicle bearing registration number so-and-so, from the informant's house, and the said vehicle was sold off for an amount of 6 lakh.
60,000
60,000
Mozmul Haq.
to one Mozmul Haq.
Thereafter, I am talking
Yes.
that part.
As thereafter, my habitual offender Mozmul Haq, that part admitted his guilt. Admitted part, Miller. The accused person has admitted his guilt that he had received the said stolen vehicle from the accused persons who are earlier arrested in this case, Miller. Where from the petitioner involvement, Miller? I have not seen in the forwarding report.
That is forwarding is the initial stage, when he was arrested, all of them accused person said it was sold to Mozmul Haq,
Yes.
Isn't for 60,000.
60,000.
And they each of them got 13,000 to 15,000, from that 60,000. Thereafter, the Mozmul Haq, he sold the vehicle to the peasant. And Lordship may kindly perish his statement, my lord. Organized crime, several vehicles were stolen at that time, my lord. And that's why it was investigated by the STF, my lord.
18 matter, no. 6 বছর, 8 বছর।
Why don't you hand it over the vehicle then? It is in your position.
Milord, after 8 years, Milord, as a police is sitting over the matter and they are silent and they failed to recover the vehicle, Milord, after 8 years, Milord. And to my information, Milord, petitioner has not involved in this case, Milord. And Milord, after
Yes,
and
statement is not
there
recorded.
too, Milord, petitioner
Statement is not mentioned about the vehicle. He said that I don't know about the vehicle. That's why I operate that he's not cooperating with the investigation.
only is that when Mozmul Haq has a enmity relation with the petitioner due to purchase of the furniture from the petitioner's shop, Milord. And that is the problem, Milord, in this case, Milord. And petitioner nowhere involved in this as per FIR, as per forwarding report, Milord. And Mozmul purchased only 60,000, and as per his statement, he has sold it 1 lakh, Milord. And after 8 years, Milord, the police failed to recover the vehicle, Milord. That too, Milord, Section 379, only 3 years, my lord. A police has to issue notice, my lord. That has not been served, my lord. And petitioner already appeared before the IO, my lord, and he has cooperated with the investigation, my lord.
Heard Mr. A. Ahmed till on the constitution. Also heard Mr. Bishop till on the additional people payment. This is an application under section Swens protection with proceedings. It is submitted by Mr. Ahmed that the present petitioner is innocent and he is not very involved with the proceedings. From the forwarding report of the other accused persons also it is seen that the vehicle was the incident had happened in the year 2018, which and 18 and the accused person who committed theft of the vehicle had already sold one of the multiple his city house. But there is no mention about the present petition. It said forward. Subsequently, the police was searching for him on the basis of statement made by the co-accused, who made such statement out of previous envy. However, he appeared before the IO, cooperated in the investigation, and his statement is also recorded. Next paragraph, Mr. Sharma, the learned additional PP submitted that the initially the 4 persons were arrested in connection with this case, but from the statement made by the co-accused persons, it is learned that the petitioner is the person to whom the theft vehicle was sold at rupees 1 lakh, but from the note of the IO, it is seen that he is not cooperating and did not disclose anything about the vehicle. Next, Mr. Ahmed, the learned counsel for the petitioner, submitted in this regard that he is not aware about the vehicle and was only the basis of the co-accused statement. The police is searching for him and harassing him to disclose about the whereabouts of the vehicle. But he had already cooperated the IO, disclosing every fact of the case, facts of the exposed. Next, however, he is still ready and willing to extend his cooperation if he is granted with the privilege of free aspect. During this submission made by the counsel for both sides, considering all materials available in the case diary, the and that the interim bail granted to the present petitioner is hereby made absolute with same terms and conditions with a further direction to appear before the investigating officer and to cooperate him, investigating officer, within 10 days from the date of order, and to cooperate in the investigation of this case, as reportedly he is not cooperating the way he should cooperate with the above observation and direction. Your absolute bail is made absolute. However, this direction is there, and it is reported that you are not cooperating the way you should cooperate. So within 10 days, again you appear and did some of cooperation. And if anything is known to you in regards to the vehicle, then please disclose it.
Vehicle is not yet recovered.
Not yet.
That is the lacuna of the policeman.
See, there's some sort of lacuna definitely from the lapse from the
State machinery is trying to recover.
Mosbul is for a long time he was not apprehended, man. That's why from his statement it reveals that it was that's why it was
Mosbul.
Fine.
Please,
Please, your lordship.
yes.
Petitioner has appeared before the investigating officer and she has deposed her statement, lordship.
You were on interim?
Yes, lordship. Interim. Now the CD has arrived, lordship. And As per the FIR goes, Lordship, the present petitioner is the wife of the main accused who is employed under the complainant's company. And the allegation is that some 50 lakhs and 40 lakhs rupees subsequently has been transferred to his own bank account. Some misappropriation of funds, allegation of misappropriation of funds is there. Lordship.
But in the wife account of the wife also some amount is credited or what?
Yes, as per the allegation on page number 14, Lordship. Page 14, Lordship. May I read the relevant portion, Lordship? Preliminary verification of salary transfer record for recent months revealed that the total amount exceeding rupees 50 lakhs has been misappropriated through his fraudulent activity. It was also discovered that significant amount from our company's account were transferred to father's bank account, namely Kishori Pathak, bearing account number so and so, Panbazar branch amount, Panbazar branch amounting to rupees 40 lakhs. Further investigation shows that he has subsequently transferred funds from his account to his wife account, Miss Savita Pathak, who is the petitioner here, Lordship. Here the employee, main accused, who is the employee of the complainant's company, as allegation is that he has transferred some amount to Mrs. Savita Pathak, who is the present petitioner. Now the present petitioner, having no knowledge about the same, neither she has received, Lordship, her bank accounts and ATMs are maintained by husband, as she has two sons, and both the bank and accounts and the ATMs are maintained by the husband itself, and she has no knowledge about the LS transferred, Lordship.
Well, in this case, I have gone for the case diary, my lord. CD I have received, my lord. Main allegation is against the husband of the present petitioner, Kamakhya Pathak, my lord. And Kamakhya Pathak, he has, my lord, misappropriated huge amount from that company. He was working as well as junior accountant of that company by manipulating the salary records of other employees, my lord. In those salary accounts of the other employees, he provided his own account number. And thereby, in this way, my lord, he misappropriated huge amount of investigation is still going on, my lord. We say some of the amount, my lord, more than 40 lakhs transferred to the account of his father, Kishori Pathak. And regarding the present petitioner, although the allegation is there in the CD that some amount also, my lord, exact amount is not there in the CD, how much amount transferred to the account of the present petitioner, my lord. She is the wife of the main accused, Kamakhya Pathak, my lord. Regarding that aspect, my lord, from the case, till now the exact amount, my lord, how much, my lord, transferred to the account of the present petitioner, my lord. Regarding those aspects, my lord, investigation is still going on.
And
otherwise, after obtaining, my lord, interim protection, she appeared before the IO, and she stated that, my lord, মোৰ স্বামীয়ে তেওঁৰ কোম্পানীৰ পৰা টকা আত্মসাৎ কৰোৱা বুলি মোক জনোৱা নাছিল। মোৰ বেংকৰ পাছবুক আদি স্বামীৰ হাততে থাকে আৰু তেখেতে মোৰ একাউণ্টত পইচা ভৰোৱা কথা মই নাজানো। That is the statement of the present petitioner.
Also,
And
Lordship,
regarding that aspect, my lord, still investigation is going on. Later on, my lord, it will come out how much amount transferred to the account of the present petitioner, my lord.
also, Lordship, all the bank accounts are frozen, and we have not tried to file any petition regarding that because investigation is going on. Even the petitioner's bank account and the other bank accounts are also frozen.
Was discovered at the time of lodging of the FIR, my lord. Later on, we found that all near about rupees 80 lakhs is in her name, my lord. 80 lakhs of mutual fund, my lord.
80 lakhs
Present
is in
applicant.
her name.
She holds in her name, my lord. Near about 80 lakhs. And my lord,
No,
those
80 lakhs
minor,
in account where it is lying?
not in bank, my lord, mutual fund, my lord.
Mutual fund.
Mutual fund, my lord. That will be revealed in investigation, my lord. And my lord, those minor childs on their accounts, in one Ayush Pathak, in his account, near about 12 lakh is there, and my lord, in Shreya Pathak, in her amount, 6,62,000 is there. My lord, until and unless lord, investigation is complete, my lord.
No, in that case, do one thing. Day after tomorrow, I don't know whether the police has already investigated to that effect or not. Interim protection is there, so let it be fixed on. Let take some time. That's what I'm saying. Let it be on 30, 31, 1, 2, that means.
Lordship,
Because,
may I submit, Lordship?
yes.
In that case, Lordship, mutual fund can be invested by any person, Lordship. Even the main accused, he can directly
Yes,
invest for
that
his
is
wife
admitted. That is
in mutual fund and his children's also. It can be directly done by the main accused also.
Yes, yes.
And this is a fresh allegation, Lordship. From the very beginning itself, all the accounts are be frozen. From the very beginning itself. My humble submission is
So
that
he is not on bank accounts. He is saying that those are in mutual fund.
yes,
So mutual fund, as you have submitted it, I do agree that mutual fund can be credited by her husband also.
as my
That
bank
is not-
accounts are frozen, even if mutual funds we cannot withdraw the
But I
mutual.
don't know whether in that aspect, whether any investigation is so far done by or not. So Mr. Bottakul, in that regard, only saying that if there is any, or what to do, Bottakul. Do you want to submit?
We will cooperate, Lordship. I will cooperate, Lordship. Already my accounts are frozen, and if that was something was there, I could have submitted in the case diary, Lordship. So many days has elapsed, Lordship. And if necessary, Lordship, we will appear, Lordship.
So you want to call for the case diary again, or but Mr. D made it in an conflict with the petition. But Mr. You, Mr. Chaudhary, A. Chaudhary, did an conflict for the informant, and also heard Mr. D. Bottakul regarding additional PP agreement. CD receipt, but it is submitted by Mr. Chaudhary that there are some recent development which has come to knowledge of the informant, that not only in the bank account but in mutual fund also there are some misappropriation of money. There are some money has been sorted, some that not only in the bank account but in the some money has been credited fraudulently in the name of the present petition in her mutual. Next para, Mr. Bottakul submitted in this regard that the updated case diary may be called for if there is any development of the investigation to that regard. In view of this, let the CDB return call for the updated one, fixing the matter on 31/3/2026.
Lordship, can it be on 2nd of April? Lordship?
2nd of April, so and so, and the interim be extended till next date of listing. However, if required, the petitioner will extend her cooperation in further investigation. Listing. Still not here.
He was here, my lord.
In this case, charge sheet submitted, my lord.
Charge is submitted. That's what why I want to say. Everyone, counsel appeared at that time. He didn't say anything. That's why we kept it pending.
Okay, my lord. In this case, my lord, PCR may be called for because 109 is there, my lord.
10?
109, my lord. Into my lord.
Okay. You are Mr.
SS Ahmed, my lord.
Are Mr. S.S. Ahmed appearing on behalf of Mr. M. Hussain and on counsel for the petition. Mr. P. Bottakul. The Mr. Bottakul submitted that case has already been charged by CS number, yes.
Charge sheet number, my lord. 20/2026, dated 27/2/26.
Where from it has to call, we don't know where it is.
Yes,
Kamrup Metro.
Yes, Kamrup.
CDM and copy of it is there along with the case diary. Estimate, right? It will be a long date. Huh? We don't have an issue.
Yes.
1st of April.
Yes.
First
My lord,
of April.
he is behind bars for almost 58 days.
No, we don't have any short.
Second week of March.
We don't have any date. They have to be on the 1st of April. Or otherwise, we can dispose of the matter. You can approach the learned trial court. That is
All right.
Report, I have not yet received. Can I take it up at 2 minutes?
Okay. At 2 p.m. He's saying that he will call for the report at 2 p.m. because for
Some
one
other-
petitioner,
some-
most
some
probably
other- Some
some
other.
other day.
Any other day, my lord.
A report. You have not received the report for all the
Report, my lord,
petitioners.
yes, only regarding respect of petitioner number 1, but there are 4 petitioners. Any other day, my lord.
It is submitted by Mr. Ford that the report is received only in respect of the petitioner number 1. And though in the last petition, the I was directed to furnish the report for the other petitioners also. In view of this, later reminder be issued and notice report be called for the concerned police station for all the petitions as to whether any case has been raised. When it can be listed?
18th.
18th. 18th.
18. 20, my lord. 20.
20 some difficulties, Your Honor. I probably
Then on 19-3.
1920, I think some difficulties will be there because Eid is there, my lord.
Regarding that report, I can get it on 16th also.
16th. 16th.
Interim be continued.
I'm impressed.
Yes, what is the position of that? Is
Yes, I received, my lord.
May it please your lordship. It's a PRS bail application, lordship. The petitioner is on interim bail, lordship. He has appeared before the IO and his statement has been recorded, lordship. Lordship, may kindly see page number 2, my petition.
Page number 2.
2.
Yes.
So there are 7 penal sections inserted, lordship. Out of these sections, only one is non-bailable, 197.2.
197.2
197.2
is non-bailable.
Non-bailable. And that section is not attracted in the facts of the case.
Lordship, 197.2 in fact?
197.2, lordship, may kindly see. Earlier, lordship, 153B.
Oh.
Imputations, assertions prejudicial to national integration. So that is not applicable, the facts of the case, lordship. Lordship, may kindly see FIR at page 11.
Page?
Page 11. May I read the FIR?
Yes.
With due respect, I beg to state that there we were worked under MS Deepak Construction Company represented by so and so as managing partner situated at Bahabari, Hijuguri, Tinsukia, and also mentioned that including some engineers as well as some workers reside in above mentioned company building. Last night at about 12:29 a.m., some group of people gathered in front of our building and playing loud music and shouting in front of our gate. And we like to mention that they have done this regularly. Every day, the whole day, there is constant banging noise, and at night we cannot sleep because of their shouting. After suffering this disturbance every single day, last night we went to stop them and ask them to keep quiet, but they did not listen to our problem. They started arguing with us and abused us with filthy languages, using filthy language. At that time, 2 persons arrived in that situation in a car and they also abused us using filthy language. Suddenly, all persons physically assaulted us, and in that heat of the moment, we closed our gate, but they did not hit the gate as well as with bamboo. They threw stones to us and our property and damages property, and we immediately called the police. And they tried to enter backside of our building, and after that, they forcefully trespassed in our premises and broke our vehicles as well as damaged the property and even kicked at the doors of service quarter in the presence of police, and then they gathered more people. When the police reached in our building, we told the police all the problems which are faced, but police take action regarding this matter, and very surprisingly, in the presence of police, they did not stop and said and also threatened us, गेट अभी तक तोड़ा क्यों नहीं, बिल्डिंग को आग लगा दो, ये हम लोग का बस्ती है, यहाँ बाहर वाला नहीं रह सकता. The police tried to control the situation, but mob was too violent and adamant, but not adhere to the police instructions. In the presence of police, lordship, it is alleged that those statements were made. These statements, lordship, that the building should be put to fire in the presence of police. It's a highly improbable, Lordship. Lordship, that 197.2 is not applicable because nothing is there to indicate that any imputation, assertion prejudicial to national integration, Lordship. And he has appeared before the IO, Lordship, recorded his statement, Lordship. So I may be allowed to, Lordship, go on in the previous bill, Lordship.
Is there a receipt, my lord? Police has collected, my lord, sufficient materials against the accuser. There are two injury report is also, my lord, available in the case diary, my lord. And there are statement of 183 statement of the witnesses is also there. All implicated the present petitioners that they are involved in disturbing the my lord, employees of that company, my lord, and thereafter on that day, my lord, they in fact assaulted and creating, my lord, nuisance in that particular area, my lord, change law. There are a detailed list of sections. Yes, all other some of the sections mixed is also there. My lord, those sections are available. My lord, regarding applicability of section 97(2), although, my lord, regarding that, whether any religious, my lord,
Religious, yeah, I believe bail objection of the IO, it is stated that they provoke and instigated the religious and exploiting the religious sentiments,
yes, ma'am.
thereby creating emotional communal
Yes,
tension in the locality. But is there anything there? I mean, from the FI, plain reading of the FI, there is nothing. Yes, obviously there are some nuisance created.
Regarding those things, my lord, those are not mentioned in the FIR. Regarding that, my lord, only on that day they were involved in creating disturbance. Thereafter, using the language, and thereafter, my lord, assaulted the employee of that company, my lord. In fact, that company is probably the actual difficulty is that company is, my lord, situated in a particular locality, so they don't want that company to continue in that area. That because of that, my lord, entire problem. Ultimately, all these disturbance.
They
Yes.
that's why they somehow they want to.
Yes.
Other sections are available and whether 197.2 will come into play, Lordship.
No, see, 197(2) is directly from the statement made in the FIR doesn't come, but
Nothing.
from the note of the IO and objection, it is in that they are creating such kind of thing. Because in that locality, most probably same people from same religions resides there, so they're trying to get the instigated those villagers. You're for whom?
Lordship, nobody is named in the
No, you're for
Akhtar
whom?
Hussain.
Akhtar Hussain.
Is there? Sir, Farid, Peer Afridi, then one Torab. These are the main part. Statement regarding communal harmony, these things are these communal disturbances or sentiments for this, so these are directly is not there.
Yes.
But I will not speak say so.
Yes.
That there are
Otherwise, they are
cases
creating
still under
disturbances, my lord.
investigation.
By their activities, my lord, they are
Hmm.
trying to create disturbance and trying to stop the activity. My lord, in fact, my lord,
Petitioner has appeared before the IO, Lordship. Record is stated.
Appear. But Mr. Anand did an start report done a petitioner PP appearing status of. And this is an application section so in connection with city receipt page submitted by Mr. Hatha, represent is innocent and there is no there, in the FI there is no name of any person mentioned in the sorry, and in the FI there is no mention of any name of any person who committed said offense. Further, he submitted that a case has been registered under various sections of law, including section 197(2) BNS, the BNS. But from the statement made in the FIR and other materials, it is seen that the case is not established under section 197(2) BNS, which is the only non-bailable section under which the case is registered. However, he submitted that the accused petitioner had already appeared before the IO after obtaining the order of interim pre-arrest bail and extended his cooperation in the further investigation. Extended his cooperation. So he is still ready and willing to cooperate the IO in further investigation. Next, Mr. Bottkul and a petitioner PP submitted in this regard that there are sufficient materials against the present petitioner, including some others, where it is alleged that they have committed such offense even in presence of the police officers. From the note of the IO also it is seen that the present petitioner is the main culprit who also provoked and instigated the sentiments of the other villagers and thus trying to create communal tension in the locality. It is further submitted that the case is still under investigation and some more facts are yet to be unearthed. Next, hearing the submission made by land council for both sides, I have also read the case diary and the case diary and the other relevant annexures filed along with the petitions. It is seen that the accused petitioner appeared before the IO after obtaining the order of interim pre-arrest bail and cooperated in the investigation. However, during investigation, it is seen that sufficient materials have already been collected by the IO against the present petitioner. But considering the other aspects of the case, including the sections under which the aspects of the case, I find that custodial interrogation may not be necessary for present for the purpose of investigation. However, his presence may be required required before the IO during the investigation. In view of this, the interim bail granted to the present petitioner dated so and so is hereby made absolute with same terms and conditions, with further direction to appear before the IO within 10 days from the date of order and to extend his cooperation in further investigation with the above observations.
Deeply obliged. May I please, Lordship? Lordship, there is no affair. An instruction was sought for multiple police station.
Yes,
Yes,
what-
I have received the instruction, my lord.
Whether any case is pending.
yes, whether any case has been registered.
Yes, the case registered, my lord.
Case registered
Yes,
against you.
case in Unmati PS case number 41/26, my
When?
41/26.
Yes, 41/26.
26.
Nunmati PS, yes.
But when registered date number. On FIR registered on my lord 10/3/2026, my lord.
10th, Lordship. The case is first listed on 27/2/2026, Lordship. February. Thereafter, on 10/3/2026, again case is listed, instruction was sought for, Lord. After thought, Lordship. On
Incident occurred on my lord 5/1/26. 26, the accused persons, namely Asa Kaur and her husband Babla Kaur, collected money from the members of the Microfinance group amounting to rupees 72,000 as daily collection money. They further assured that they would repay a total amount of rupees 9,99,000, but till that they have not paid any amount. The complainant further stated that on 5/1/26, the accused persons took rupees 8 lakhs, and again on 8/2/26, they took rupees 2,50,000, promising that the money would be repaid through monthly collections. However, they have not returned the said amount till that. When the complainant demanded the money back, the accused person allegedly used. So these are the allegations against Asa Kaur and Babla Kaur.
Lordship, FIR.
We were not on that case. The case, as per the report,
Yes.
or as per the FIR, the incident took place on 5/1/2026. There may be some reasons, I don't know, the case was not registered.
Preliminary inquiry, my lord, conducted.
Preliminary inquiry was most probably going on, then therefore after the case is registered. Now your submission is that the on the entry also the report, no report was there, and thereafter.
They lost
But
this.
after thought or what thought it will, that
Yes.
will be different, but
Yes.
anyway, the case is registered.
Registered.
So we are calling for the case diary at present.
Yeah,
What
yes.
to do?
Yes, Nunmati PS case number 41/26.
Yes. Heard Mr.
D. Sutials.
D. Suchya, the learned counsel for the petition, also heard Mr. Report, the learned edition, the state response. Report received from the concerned police station whereby it is stated that case under Nunmati PS case number 41/2026 has already been registered against the present petitioner in connection with the incident which has reported on 5/01/2026. In view of this, let the case diary be called for in connection with Nunmati PS case number 41/2026. When it-
Protection may be done.
Hmm?
Interim protection may be civil.
We have nothing before us now.
On 23/26 months.
We are giving you short date, 23. City we call. We're calling for the city. Let's see if it is the case of an interim, then we'll provide.
Obliged.
May I please your lordship? Matter may be fixed at 2 p.m. lordship.
If other matters starts, why 2 p.m. He is also here.
Lordship, my senior is in court number 3, lordship. Hearing matter is going on, lordship. So
We'll suit you. We cannot say at 2 p.m. it will be. If other matter starts, then it may not reach also. Anyway, we are putting it at 2 p.m. Yes, okay.
deeply obliged.
But it's a timing we have to keep it. 2 p.m. can be. And appears on call for the petitioner as well as the respondent. List. Heard Mr. P. Borthakur, United Nations PP, appearing on behalf of state respondent. Lynching matter accordingly after 2 weeks as on a date.
CD9. Well, in this case, CD was from the CD.
You are, Mr. Day is for the
Respondent
respondent.
number 2 million.
Respondent number 2.
Two
State is for 1.
Yes.
Yes, you are for the petitioner?
Yes, Your Lordship.
Ah.
Your Lordship, the interim that was passed shall may continue, Your Lordship.
No, that cannot be your submission. Your case is at the stage of
Your Lordship, as we are informed by the learned PP that the CD was called for and it has not been arrived yet, Your Lordship.
CD not received here?
There is an interim.
You have not received the
Last
case that
option, we cannot record.
case is still under investigation or what? Investigation.
Your Lordship, a numerous adjournment has been taken by the prosecution for the specifically because the CD has not been received, Your Lordship. Kindly, the court may direct the CD to be produced in the next date, Your Lordship.
Interim it is. What kind of interim it is? Interim means
Initially, there was no interim order, my lord.
On 9/1.
where is the interim?
9/1/2000.
Interim order.
Recorded that the interim.
9/1/2000.
9/1.
That is when what she's saying, my lord.
We recorded.
9/1. Your interim was considered on 9/1.
Yes, Your Lordship, we have recorded on 9/1/2026, in the order of the Honorable High Court that the interim shall.
Interim to this.
Only notice issue করছে
There is no interim order as such.
if your lordship sees the first order, my lord, 16
yes.
and 25, there is no interim order.
No interim.
And in fact, my lord, no interim order would otherwise be passed, my lord, because it's investigation cannot be stopped.
Yes, cannot be stayed.
So,
That's
my
why
lord,
we're just
question-
searching it.
yes.
Where is the interim order?
Probably not. For some reason or the other, my lord, submission was made probably. My lord, that-
Submission was made that
Probably.
interim is there, but no
Probably.
such interim
There
is
is no
there.
interim order.
It was very wrong submission made, I don't know on whose behalf, but
Probably without
it
going
is
through the courts.
wrongly submitted, and the court on good belief passed that the interim is continued. In fact, there is no such interim. There's no such interim. On which date you got the interim, we don't find it any.
Your Lordship, on the order that was passed on 19/1/2026.
19/1.
Yes, Lord.
It is your wrong submission from your side that interim is there. So on good belief, court had passed the order of that interim be continued. In fact, there was no such interim. Don't make such submission. Unless you go through the case record, don't make such. For your wrong submission, the order of interim is there. In fact, there is no such interim. You are MS?
P. Kashyap.
Hard MS P. Kashyap. Your name is not here?
No, Your Lordship.
Appearing on behalf of Mr.
A.K.
Bhuya?
Bhuya.
Hard MS P. Kashyap, the learned counsel, appearing on behalf of Mr. A.K. Bhuya, the learned counsel for the petition. Also heard Mr. P. Borthakur, the learned additional people, and Mr. R. Day, the learned counsel, appearing for the respondent number. It is submitted by Mr. Borthakur that CD not received. CD not received. Post of issue reminder to that conference. It is seen from the record on 19/1/2026. And order of continuation of interim was passed. So there's no such interim protection or interim order was passed by this court. In view of this, let the reminder be issued, CD be called for. Yes, when it can be called.
Your Lordship, after 22nd of April, Your Lordship, my senior will be out of station.
22nd of April.
Yes, Lord.
2/8. 2/8. Okay, then we'll see it on 2/8.
Obliged.
20th of April. April. 20th. Submission আমাকেও দিয়ে গেছে বা interim আছে বলে interim এ নাই কোথা যায় interim আছে interim থাকা বুলি কৈ দিয়ে মিছামিছি চাব লাগে ক'ব লাগে এনে interim থাকা বুলি
So with the consent of both the seniors, my lord, can it be taken up for my lord admission hearing on 2nd of April?
But Most probably, she is also appeared.
Private respondent is there, my lord. They have appeared.
And state is also there.
State, my lord, Nagaland is there, my lord. On 2nd of April, my lord, if possible, my lord,
2nd of
for
April.
hearing.
Otherwise, you are for the
I am for the
petitioner.
petitioner, my lord.
And the respondent, Mr. P.J. Sekar, senior advocate is there.
Yes,
You are
correspondent.
with the consent of the arrested, would the learned counsel for the petitioner. Mr. Gogol's when adjournment there. On second, when second?
2nd of April, my lord, that's a Thursday.
2nd of April.
Yes.
Okay for you? You can come on 2nd. List accordingly. 2nd. Okay, we are listing it on 2nd April in addition.
My lord, there is an interim that may continue.
Interim be considered.
26/9/25, that's the order.
Okay.
May I please, your lordship, in
Yes.
this matter here, a CD was called for.
Here also CD was called for. What?
CD not received in this case.
Pardon?
CD not received.
Not received. It is a, I mean, charge sheeted case or what?
From this, they have challenged the FIR for passing.
FIR?
Challenge the passing of the
Okay, well,
FIR.
scan for whom
If in the meantime, I'll search it, submit it, I'll have to.
Was it? What? Yes, that's it. They are bringing for quashing of FIR.
FIR.
Case is still under investigation, I think.
Yes.
Do you have any idea in that regard? Whether case has already been charged or still under investigation? As per your petition, case is still under investigation, most probably. You are MS?
Yeah, friend.
A Afrin.
There is a 1/8/25.
Now to 9. Oh, had MSA Afrin, the learned counsel for the petition also had Mr. P. Water. It is submitted by Mr. Water. CD not received. Issue reminder. List, yes, support approval.
On my lord,
1st of April will do.
yes, first or second?
Second.
2nd of April.
2nd of April, so and so. List the matter. No, issue reminder directing the IO to furnish the case diary on or before the next date of listing. List the matter accordingly on 2nd of April in admission hall.
Ready to. Helium test.
No, we should take it. We have received the copy of affidavit. They have filed one affidavit. We have received now.
Yes,
Affidavit you have
copy of the
received.
additional affidavit is not in my file. But this is an NI case, madam.
Oh, NI.
NI.
Then who is the other side?
Your lordship, I'm appearing on behalf of A. Rahman. His name is there in the punch list and my
No,
name
no,
is.
I'm not on that. Who is the other side?
The other side is your lordship, as per the complaint case, his name is some
Notice not yet issued, madam.
Ashish
not
Kumar
yet
Kanu.
issued, no?
Not yet issued.
Oh.
And your lordships, to my notice, I really seek apology for that. In the main petition, the respondent number 2 has not been made a party. That means the complainant of the NI Act case.
Oh, madam.
And even I am, I'm really sorry. It has been filed by somebody else, your lordship, and I'm appearing on behalf of him. That he should have been made a party, and I seek the apology for that. Bringing this to the point.
Because of that, madam, petitioner is directed to file an additional affidavit. Otherwise, madam, he has to make party the main complainant of the case.
And I leave it to your convenience, your lordship.
Withdraw. Otherwise, he has to withdraw this petition and file.
It will be different. So
Only NBWA was issued to me and it was issued by the state, Your Lordship.
order will order will additional affidavit.
He has approached against NBW,
NBWA.
but on the
Party. You do one thing. I'll just passing an order of withdrawal on some technical irregularity. And immediately this week only you can file a press petition. That will be entered. Otherwise, it's not here.
I get you.
Your good name?
Sure. And my name is not there in the post list. On behalf of A. Rahman.
Sure. The learned counsel appearing on behalf of Mr. A. Rahman, counsel for the petition. Also had Mr. P. Water, the PP appearing on behalf of state respondent. As per in-person to the order dated 27 to 2026, an additional affidavit has been filed, bringing the order sheets in the case record. However, on perusal of the record, it is seen that perusal of the record as well as pointed as pointed out by the learned counsel for the petitioner, the informant the complainant is not with party in this case, who is a necessary party in this case as the case relates to NI case. In view of this, the learned counsel for the petitioner submitted that due to this technical irregularity, he may be allowed to withdraw the same with a liberty to file afresh. Considering the submission made by Mr. Sur, the learned counsel for the petitioner, the prayer is allowed. Cases accordingly disposed of on withdrawal with a liberty to file a press. With a liberty to file a press if so happens. Okay, then we did this week, you can.
If you are present.
Tell ke padane. The time besides me. Oh, tell me. Additional security. One record was called for, no? Criminal appeal. Criminal appeal. And I get why and I on a criminal appeal and I can do revision. Who is it for? Can I get it? It was very cool. Every day in the phone can I get? You know what? আৰু হেৰি নোটটো পিছত বেলেগ এই হেৰিৰ কাৰণে না সেইটো বুজিছো আৰু বেলেগ ন আৰু পাৰ্টিৰ ষ্টেপৰ কাৰণে সেইটো একো নাই an application call for the petition. However, from the office notes, it is seen that the case record could not be sent by the land additional CGM board data as the original case record could not be traced out till date and accordingly create some more time for sending this in. In view of this, let the reminder be issued and further it is seen from the record that the petitioner has not taken any steps for issuing notice to the respondent. In view of this, the petitioner is also hereby directed to take steps on the respondents. This the matter accordingly after 3 weeks as on a date to be fixed by the registrar. আৰু এটা বস্তু
that is code number 10. And because of that, I missed my item number. It was 17. So this honorable court was pleased to count as a non-appearance from the side of the petitioner. I was appearing on behalf of my senior counsel, who was in previous travel today, because of which he could not make his presence.
Anyway, we did not pass any other adverse order, but your absence is recorded, and we listed it after 2 weeks.
After 2 weeks.
After 2 weeks.
Your
No
Honor,
other adverse order is recorded.
Your Honor, sorry. And my lord, the earlier interim order was also there.
Interim was there.
Interim order was there.
Okay, we'll intimate.
May it please your lordship, I'd like to mention item number 11, your lordship, which got passed over because my senior was in another was engaged in another court. Your lordship,
We have listed it after 1 week.
Your lordship, the matter is urgent. Your lordship.
Sorry, no order.
With your lordship. Lordship,
Yes.
I'm praying for 10 days time for taking steps, lordship.
Your this
Edas, lordship.
no. Your petition is
Delay petition, lordship.
delay petition is also there, when leave petition is also there, I think. No?
Lordship.
So you have not taken steps.
Lordship.
Your MS?
Edas.
RMS that's petition. Submitted by MS does that inadvertently she could not take steps for the respondent. In view of this, the petitioner is appellant is hereby directed to take steps on the respondent in 4 days to register DD and initial process. Please see matter accordingly. Cannot fix a date because I don't know when, because it is a case of 2020, but till that it could not even admitted, na?
Lordship.
So delay not yet. You want any fixed date here or
Lordship.
after 2 weeks?
Lordship.
Okay, after 2 weeks as an edit 2 weeks by the registrar.
Lordship,
yes.
Lordship, in this case, the notice was issued to the address of the informant, Lordship, on 25/5/2025. Last occasion case was listed, but after going through the office note, Lordship, I have wrongly submitted before the service is awaited. It is already about 1 year, Lordship. Then a presumption may be taken under section 20.
Which date you referring to? In which date you are saying that it was, notice was served?
Not served, notice was issued, Lordship, on 25. 25/5/2025.
Better to issue fresh notice, I think.
Now.
Yes, well, after 1 year, I don't know what is the stage of within 1 month, you could have track out the consignment report also, but at this stage, so better take steps, I think. Fresh steps you take, I will
Yes,
see to it.
By register post.
At present, to not register post, but speed post.
Speed post, yes.
Speed post.
Yes, Lordship.
And the state is one of the party.
SP number 1.
Your SP number 1. RMS MDIP, the learned counsel for the petition. Also heard Mr. B. Sharma, the learned additional PP, appearing on the opposite respondent. It is submitted by MS Dave that this notice steps were taken for the petitioner in the year 2025, but till date, no report has been received by the concerned section. In view of this, as the notice was issued about 1 year, let a fresh notice be issued to the respondent number 2 through a speed post and initial plan. list the matter accordingly. After 3 weeks, we'll do.
Lordship, the date may be fixed on 27th of April, 1 month after 1 month.
Oh, 27 4.
Of
Listing.
April.
Yes, it's 27 4. We are listing it.
Oblige.
May I please your Lordship?
Yes.
Lordship, this is a jail appeal, and there has been a delay of 1041 days.
1041.
Yes, 1041 days in filing this appeal. And we have served the copies of the petition to learned amicus curiae.
No, that is okay. But why it is so much of delay?
Actually, the appellant was clueless, and there has been some difficulties for him to reach out to get legal service. It's a legal service matter, my lord. I'm a legal aid counsel.
Yes, MS Brown, it is a jail appeal, so appeal can be.
Yes, your Lordship, no.
RMS as date as made in counsel for the petitioner. I do deliver. And also heard Mr. B. Sharma, the learned additional PPP. And MS MK Brown, the learned amicus, the respond number. And this is an application. The section 5 of the Limitation Act for following delay of 1041 days in referring the connected appeal against the order of conviction under conviction passed in special POCSO case number 25 of 2018 by learned additional session judge come special judge POCSO Sipsagar. MS Mehdi further submitted that as the case has been filed from the jail, the appellant could not make any contact with the Legal Aid Services Authority of the High Court, and somehow with the help of the state superintendent, the matter was referred to the High Court Legal Services Authority, and accordingly she has been engaged as a legal aid counsel. And thus there is a delay of 1041 days preparing the connected act. However, there is no intentional latches on the part of the appellant in preferring the appeal within. Mr. Sharma, the learned additional PLP, raised no objection in condoning the delay, and at the same time, MS MK Brown, the learned amicus, appealing for the respondent, for respondent number 2, also did not raise any objection in condoning the delay. In view of this, the present I is hereby interlocutory application is hereby allowed and allowed considering the ground mentioned in the petition as the justified ground. Accordingly, the delay of 1041 days is hereby condoned. The registry is accordingly directed to register and number the connected appeal. You want your name to be reflected? Yeah. The registry is also hereby directed to reflect the name of MK Brown as an amicus at the time of registration of the appeal, as well as the name of MS as made may also be.
I'm highly obliged, Lordship.
In matter, I have entered appearance for respondent number 2. I have freshly entered appearance. If I seek to file a written objection.
So, as you have entered into appearance, service is completed.
Which is another respondent. Respondent number 3.
Respondent number 3. Oh, achha, achha. So you are not going to represent respondent number 3. So most probably you are number 2, it is a block development officer.
Yes.
And number 3, one personal name is there, Palash Jyoti
My
Datta.
predecessor,
What is this? Service is still awaited for the response number 3. And you have not provided with the copy
I have been provided a copy by.
you have received. You are going to file any objection here?
Yes, but I'm paying for 4 weeks because I posted in Lucknow.
It's your good name?
MUE, Your Honor. UE. My name is not there in cause list, Your Honor. I am appearing on behalf of my senior, KVR.
Bhuyan.
Yes, Your Honor.
Now your good name, what you have said?
MUE Bhuyan.
MU?
Bhuyan.
MUE Bhuyan. Appearing on behalf of Mr. K. Bhuyan, the learned counsel for the petition, and also her. You are Mr.
Atria. A-T-R-E-Y.
Atria. Atria. Appearing for the respondent number 2. And also heard Mr. B. Sharma, the learned petition PP, appearing for the state respondent. It is submitted by Mr. Atria that they have already received the copy of the petition, but needs some more time to file the written objection to the In the same time, it is seen from the office note dated 11 3 2026 that service is still awaited for the respondent number 3. Let the service be awaited till next date of listing. In this post let the matter be accordingly listed after 4 weeks, enabling the respondent number 2 to file his written objection if any. Listed. Okay.
May I please, Your Lord? What's your review petition has been filed in respect of the rate of interest lot. Notice may be issued also.
For rate of interest.
Rate of interest.
Okay, we'll issue notice here. What was given?
9%.
You need 16. How much you need?
At least minimum 12.
Okay. You are Mr.
A Brahma Lord.
Part Mr. A. Brahma, the learned counsel for the petitioner. This review application has been filed under section 114. Date with order 47, Road 1 CPC for review of the judgment dated 23/10/2025. Passed by this court in MSC appeal number 27 of 2009. Issue notice to all the respondents to speak post in usual process. Let the matter be accordingly listed after 3 weeks as an date to fixed by fixed. You take steps to divide.
Much obliged, Lord.
My Lord, in this case, what has happened, my Lord, having realized, my Lord, that the interim order is in fact impacting me. There is a stay, my Lord. Your Lordship was right in saying while passing the order that it will delay the proceedings, my Lord. So now presently I am asking for closure of the petition with an innocuous, my Lord, observation or direction. The next date is fixed on 17. My Lord, in fact, here what has happened, the appellate court has admitted the appeal and suspended the sentence under the NIA, my Lord, without consideration of 148, which requires, my Lord, payment of 20%. So I'll file an application before the appellate court on Thursday 17. Only observation what I'm asking for, that the appellate court, my Lord, will consider and pass appropriate orders within, my Lord, a certain period, say 4 weeks or 1 month, my Lord, after hearing both the parties. And without
appeal,
my Lord. And without, my Lord, consideration of my application, the appeal may not be disposed of. Otherwise, the 148 will become redundant. Because
So you want to file in 148 before the appellate authority.
Appellate authority. Because your lordship is aware, Supreme Court, my lord, in that case, I have filed, my lord, submitted the judgment also, Surinder Singh Deswal, that one, my lord, the compensation under 148, my lord, is required to be considered either on the application of the complainant, where I am the complainant in the trial court, or, my lord, under the application under 389 of the CRPC for suspension of the sentence. And when the, my lord, sentence was suspended, essentially there was an application by the accused. But at that point of time, 148 was not considered. So therefore, my lord, it's not only violation of the apex court judgment, but also 148. But I'm not going to that aspect of the matter. To expedite it, my lord, your lordship will only say that it will be considered within a fixed period, 4 weeks time. And on 17th, I'll file the application. Only that much I'm asking.
On 17.
Yes, it is fixed on 17. I'm only asking for that. And my lord, at page 28, the appellate court has made clear, which is in my favor, my lord. If your lordship comes to page 28 of my appeal, criminal petition, the appellate court has mentioned that the operation of the sentence imposed by the interim judgment and order shall remain suspended until further order of this court. So, my lord, the appellate court would also be entitled to pass appropriate orders in terms of para 5 of the order, dated 15/12/25. Only that much, my lord. And your lordship may close it, ma'am.
But Mr. S. the counsel petition. It's an application at ASIP again, liquid about White order dated 25/02/2026. 26, the scan copy of the DCR was called for and the matter was admitted. No, a scan copy of the DCR was called for and the proceeding in criminal appeal number 117/2025 was also passed. But Mr. But Mr. Talukta at this stage submitted that he may be granted liberty to approach the learned appellate authority with a press application for bail, seeking 20% of the compensation amount as per provision of 148 Act. He further submitted that the operation of you need not do these things.
My lord?
Only you seek a liberty to file a fresh application.
Yes, only one lord. I'm asking for the direction that it should be considered within 1 month, my lord.
Accordingly, submitted that he doesn't want to place the petition further. However, paid for a direction. However, paid for a direction to the learned appellate authority to dispose of the matter within a reasonable period. In view of this, the present petition is hereby closed. The petitioner is at liberty to file a fresh application seeking 20% of the compensation amount as per provision of 148 of the NI Act on next date of listing, that is on 17/3/2026. In the same time, the learned appellate authority will dispose of the said application within a reasonable time, preferably within 4 or 6 weeks. In view of this, the present petition stands disposed.
And my lord, without consideration of that application, appeal may not be disposed of. In the meantime, if the appeal is taken up, my lord, that observation may be there, my lord.
That can.
At least, my lord, the para 5 observation that may be there. Because the appellate court, my lord,
No,
will have the.
actually, you did a mistake. Appellate authority, you could have filed the application. But now we cannot say that the appellate authority will, what you have submitted, that petition I have already recorded that within preferable 4 or 6 weeks that may be disposed of. May grant, may not grant, that is up to
Yeah,
the court.
that is yes,
up to the
that is
court.
correct, my lord.
So accordingly, it will be decided.
Lordship will say 4 weeks, my lord.
Yes, I have seen 4 or 6 weeks because I don't know what is the position of the case pendency or the overburden. So that's why 4 or 6 weeks I have given.
Yes, correct.
Will dispose of. Yes, sense disposed of. Or stand closed. Okay, we are closed.
I'm obliged, man. The problem is, my lord, in criminal appeal, we cannot file caveat, my lord. That is why, when the matter was taken up, ex parte it was taken up. Only when the notice was received, my lord, I came to know about the order. That is the problem, my lord. I'm obliged.
But we are always at liberty to file a 148.
Yes.
But that you have not done initially. Now you can file an application, and at any time it can be.
My lord, in fact, there was a point, my lord, which was required to be decided. But since it will delay, my lord, or protract the appeal, therefore I have, my lord, sought for the withdrawal or closure. In fact, the point is, which on that day your lordship also deliberated with me, the point is whether or not the appellate court is required to decide while admitting the appeal.
Yes.
Because if, my
Now,
lord, the appeal is
as per
stayed,
your research, what is said?
my lord, in fact, my research is reading, my lord, 148. It appears, my lord, that if it is not taken up at the time of the appeal, in terms of the Supreme Court judgment, then it is amounting to render, my lord, 148 as redundant. Because the Supreme Court has, my lord, interpreted the may as shall, my lord.
That I know,
148
may
is
and
mandate.
shall.
Yes.
Those, as per statute, it is may.
May.
But in cases the Supreme Court had held, it is may stands shall.
It has
That
to
is
be,
okay.
yes, it has to be considered as shall, but appellate court is at liberty to reject it. It's a different aspect of the matter. But consideration is shall, my lord. That's what I understand. In appropriate cases, your lordship
Other judgments also, wherein it is may is also there. Let us see.
No. Apex Court said, having regard to the object and purpose of 148, in this particular context, in different judgment, that will be different, my lord. In this particular context, the may has to be read as shall. In this particular context, my lord. I'm obliged, my lord.
It's one of the full on.
Step 9. Step 9.
Yes.
May I please, your lordship? So this, my lord, 120 proceeding, my lord. And here, my lord, the petition filed, my lord, on 6/12/2021. And written statement filed, my lord, on 26/5/2022. And then, my lord, the petitioner, my lord, he's a, my lord, CISF constable, my lord. And he filed an application, my lord, to allow him to engage advocate in the proceeding. And the application was rejected, my lord, page 30 on 19/7/2022, and case fixed for evidence. Page 30, my lord.
Yes.
And it was fixed on 22nd of August 2022. On 22nd of August, my lord, he was not granted leave, my lord, by the authority, so he could not appear. And case fixed on 30/9/2022, my lord.
No, but which is your impugn order? Impugn order is 19/7.
Lordship. Impugn order 29/10, my lord.
29/10. It has been page?
Page 38. On the third day, my lord, it was fixed on 30/9/2029, and on 30/9/2022, my lord, he was posted at, my lord, Madhya Pradesh, my lord. Next day, the judgment has been delivered. On the last occasion, my lord, I paid before the small court, my lord. That is a case of remand, my lord, because no opportunity has been given.
But you have filed your WS already.
Lordship,
We are not getting any opportunity of adducing evidence or what?
Lordship. Neither to examine the, my lord, respondent.
So now what is your prayer?
My lord, the impugn order may kindly be set aside and matter may remand, my lord, from the stage of cross-examination, my lord.
So your main ground is that you are as a what personal BSF person?
Lordship. And at the time of judgment, my lord, he was in duty, my lord, and Madhya Pradesh, my lord. I have annexed his document, my lord. Page 32 and page 32. Page 32, my lord. He was, my lord, Madhya Pradesh, my lord, from 12/9/2022 to 8/10/2022.
Just a second, 12?
12/9/2022 to 8/10/2022. Page 32, my lord, in the first paragraph. And his serial number 1, my lord.
So for only 1 month?
Lordship, for training, my lord.
Acha, for training. Training in which?
Training for promotion.
LP.
Lordship. Promotional training, my lord. The following so and so are directed to proceed to RTCS Bharawa to attending promotional cadre course.
Otherwise, marriage and
Nothing.
paternity of the child is
Not disputed. Not disputed.
Yes. Now let's just louder. You try to on paper. Is it on?
Petitioner is the CISF. He getting the salary more than 60,000. And he filed his written statement and assessment liability lordship. And after that, he was there. Only cross examination has not conducted by the husband side. And the Senate family could rightly pass this order for the wife and the minor children.
No, they are not disputing that. They are disputing that they did not get the opportunity of a hearing or opportunity of cross-examining the PWs as well as adducing his evidence to establish his own case. That is his submission. So a matter is pre-judgment because he was not in, it is case of Borpeta.
Lordship, Borpeta.
Borpeta, but he was in outside state.
And my petition for engagement of advocate was also rejected.
That is history. So in that case, do you want, you have any objection if matter is remanded back?
But matter may be remanded, then you take the maintenance order. Okay? That may be.
No, that we are not going to stay. We are not going to stay because it is a maintenance case, but matter may be remanded to for fresh disposal.
Lordship. And
But award which has already been granted or the maintenance award,
Lordship.
we are not going to touch at this stage. But have you getting any maintenance till date?
no, he's paying. I'm paying, my
He
lord.
is paying.
Lordship.
Then he is paying.
There is some.
There is some area, my lord. Otherwise, because effect was given from the date of filing, so there is
So
some
there are
area.
some area.
Yeah.
It's okay. There are
He's
some
paying,
area,
my
but otherwise he is paying.
And there's a still one portion has been stayed by the small court.
State.
Lordship, I'm
Well,
paying, my lord, 10,000, my lord.
You are now paying at 10,000.
Lordship.
Okay, in which date? Right, for which date?
Order dated 22/6/2023.
So to now you're paying 10,000. Heard Mr. R. Ali, the learned counsel for the petitioner, and also heard you, Mr. MJ Shah. No? MJ Shah, the learned counsel for the respondent. This is an application under section 397/401, read with section 482 CRPC against the impugned judgment in order dated 29/010, no, sorry, 29/10/2022. Passed by learned principal judge family court Borpeta in FC bracket of criminal case number 561 of 2021, directing the petitioner to pay an amount of rupees 10,000 per month towards the maintenance of the respondent and rupees 5,000 per month to the minor daughter from the date of filing of the petition. Next, brother. Mr. Ali, the learned counsel for the petitioner, submitted in this regard that the respondent had instituted an application seeking maintenance under section 125 CRPC before the learned principal judge family court Borpeta, alleging some alleging interrelated that alleging some mental and physical torture as well as demand of dowry, etc. After receiving the notice in the safe case, the present petitioner appeared as a second party and filed his written statement accordingly, wherein he denied the case of the petitioner as case of the respondent. Full stop. However, the marriage and the paternity of the child is not disputed by him. Further, it is also not disputed that he is a CISF constable, and has the capacity of alia. But as he had to be posted outside state, he filed a application before the learned principal judge family court, praying for engaging an advocate to conduct his case. But by order dated 19/07/2022, the learned principal judge had rejected his prayer for engaging counsel and engaging in counsel to defending his case. As no counsel could be examined on his behalf, and as the petitioner had to remain outside state of Assam due to his engagement in the department, he could not appear before the learned principal judge family court for adducing his evidence, and he also did not get any chance for cross-examining the PWs. He further submitted that at the time of delivery of the judgment, he was at Madhya Pradesh for his promotional training for the period from 12/9/2022 to 8/10/2022. Subsequently, he came to know about the order of ex parte judgment passed against him, whereby he was directed to pay rupees 10,000 towards maintenance for the respondent and rupees 5,000 towards maintenance for her minor child. The petitioner further submitted that he is still paying the maintenance at the rate of rupees 10,000 per month in view of the order passed by this court, to good.
Twenty-two six 2020.
Dated 22/6.
23, madam.
23. But as he did not get any opportunity to substantiate his plea taken in the WS by examining his witnesses or by cross-examining the PWs, the matter may be remanded back for fresh disposal, with giving an opportunity of hearing to both the parties. In that context, he also submitted some documents to substantiate the plea that during that relevant period of time, he had to be outside Assam for discharging his duties as a CISF constable. Next point. Mr. Shah, the learned counsel for the respondent, submitted in this regard that after receiving the notice, the petitioner appeared before the learned court of principal judge and filed his written statement, wherein he took all the plea and they also denied the case of the respondent. But subsequently, he failed to appear before the learned trial court below, and for which the case proceeded ex parte, and the order was accordingly passed. Mr. Shah further submitted that there may not be any interference in the award passed by the learned principal judge, as the petitioner is getting more than 60,000 per month towards his salary. Mr. Shah further submitted that the notice was duly served on him, and while passing the judgment, the learned principal judge also considered the statement made in the written statement by present petitioner, and hence there may not be any order for remand for fresh disposal of this case, and the learned principal judge Bamlikar had already considered all the aspects of the case, including the income of the present petition. Next, hearing this submission made by learned counsel, since I perused the case record, may be seen that one petition was filed seeking legal help appointing a counsel on his behalf to proceed on his behalf, but this said prayer was rejected by the learned principal judge Family Court Borpata, by its order dated 19/07/2022, with an observation that as per section 13 of the Family Courts Act, ordinarily there is no legal right vested to the second party to get represented by his lawyer. But from the submission made by learned counsel for the petitioner, it is seen that the petitioner was in a situation wherein he was prevented with sufficient cause to appear before the learned principal judge on day-to-day basis as per his service condition, who is discharging his duty as a CISF constable. More so, the marriage and the paternity of the child is not also disputed in this case. However, it is a fact However, it is a fact that the petitioner did not get any opportunity to substantiate his plea either by cross-examining the PWs or by adducing his documents. His documents more so. From the submission made by Mr. Ali, it is seen that the petitioner is still paying rupees 10,000 per month to the respondent and her minor child in pursuant to order passed by his court. It is a settled position of the provision that as per the Family Courts Act, the appointment of a appointment of a counsel cannot be claimed as a right by the second party, but it can be allowed if it is considered to be necessary for the interest of the justice. In the instant case, it is seen that being a CISF constable, his duty may be outside the state, and which may be a hurdle for him to appear before the learned trial court below at Porpeta to on each and every date and to confess the case. So considering all these aspects of the case, and the submission made by learned counsel for both sides, and this court is of opinion that one opportunity may be given to the petitioner to substantiate his plea taken in the written statement, and also to cross-examine the PWs. However, and hence it is of the opinion of the court that case may be remanded back for a fresh disposal by allowing the petitioner to cross-examine the PWs and to adduce his evidence. However, it is made clear that no stay order is passed in providing maintenance to the respondent and his child as per direction of this court, and the petitioner will make the payment, will continue the payment until the fresh order is passed by the learned trial, by the learned principal justice. With the observation, the present rebellion petition stands. With the 10,000 we have considered, that will be continued by the court, and we'll make a observation on the learned principal just family court Porpeta is also hereby directed to dispose the matter afresh preferably within 6 months. They will dispose of the matter. In the meantime, you will get the maintenance of rupees 10,000. We have not passed any order of maintenance earlier granted by the though it's
directed to pay the earlier that will be adjusted from fresh amount.
that petition you can very well approach before the learned trial court below to give you a chance. Otherwise, we're not setting aside the entire record because order of maintenance will be still there, but one chance will be given to the other side for adducing his evidence and to cross-examine. Otherwise, you will get the 10,000 per month as per the
Time period may be given to complete the entire proceeding, Lordship.
6 months I have. Preferably within.
Blessed.